David Pickus. This is Mr. David Pickus before the court in 25 CF 196. Your Honor, I just wrote up this plea agreement. We've reached a resolution. Just need to grab the state's signature, and then may I approach?
Sure. All right, Mr. Pickus, can you raise your right hand? Do you swear or affirm the testimony about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your full name and date of birth?
David Stephen Pickus, August 3rd, 1993.
Mr. Pickus, you're here in 25 CF 196, charged with possession of a controlled substance and driving while licensed suspended felony. Those are both third-degree felonies, punished by 5 years of incarceration each. Understand that?
Yes, sir.
All right, and I've been handed a plea and sentencing agreement that calls for you to plea to count 1 only. Count 2 would be dismissed, but on count 1 would be 18 months probation, substance abuse evaluation, and recommended treatment, adjudication of guilt. So that would be a felony conviction. Court costs would be $615. Court costs? $615. Okay. All right. As announced, okay, and $150 cost of defense. Is that what you want to do today?
Yes, sir.
Or is that the state's agreement?
It is, Your Honor.
You know, I'm looking at the guidelines there. It's 22 points, or 22.1 points, so there's no lowest permissible. All right, Mr. Pickus, did you go over this plea and sentencing agreement with your lawyer?
Yes, sir.
Did you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Page got flipped over. All right, are you satisfied with your lawyer's advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for the plea?
No, sir.
You understand by entering a plea there won't be a trial of any kind?
Yes, sir.
Do you understand you're giving up your trial rights that are listed on page 2 of the agreement you signed?
Yes, sir.
And do you understand you're waiving any potential defenses?
Yes, sir.
Do you understand that if you're not a U.S. citizen, this could lead to your deportation?
Yes, sir.
All right. And what is your plea to the possession of controlled substance?
No contest.
State having I'll accept your no contest plea as freely, voluntarily, knowingly given. State have an announcement on count 2.
State will dismiss count 2, Your Honor.
Okay. And on the count 1, it's going to be 18 months probation, substance abuse evaluation, any recommended treatment, adjudication of guilt, $615 court costs, $150 cost of defense. That will be part of your probation. Again, like I said, this is a guideline sentence. Mr. Pickus, I need you to be fingerprinted, and then you'll talk to probation after that.
Yes, sir.
And then you'll have 30 days to appeal the judgment and sentence of the court. All right, thank you. Oh, cost of supervision waived due to the fact that he's indigent and represented by the public defender.
Your Honor, next up I have Barbara Abrams. I believe Mr. Klein's called her as well. Ms. Barbara Abrams. Okay, she's still not here, Your Honor.
Okay. For Ms. Abrams, we'll go ahead, and it was what we did on her other cases was a capias to set a bond on at first appearance. I'm sorry. Ma'am, are you on your phone? Okay. Well, you're holding it to your ear, so. Well, if it's ringing, you can't answer it in here. Okay. All right, thank you. Next.
Yes, Your Honor. Jeffrey Baker. Your Honor, this is Mr. Baker, present approaching before the court in 25 CF 157. Your Honor, we were just waiting on a competency evaluation report. I've reached out to Dr. Zeman. He should have that to us this week. Unfortunately, we don't have it today. If the court is okay with it, I would recommend placing it on the July 10th docket.
Have they given you any indications what the report's going to say?
No, Your Honor.
Okay.
Just email correspondence.
All right, we can put it on July 10th at 2 o'clock for status as to the competency report. So we'll need you back on that date, sir.
Sir.
Okay. And your next pretrial will be August 25th at 1 o'clock. All right, thank you, sir. Make sure you stay in touch with Mr. Maddox.
Thank you, Mr. Baker. Linda Carroll. All right, this is Miss Linda Carroll. She's before the court in 24 CF 1615. Your Honor, I have a signed pretrial intervention agreement if I may approach.
Yes.
It does say the $40 cost of supervision on there. I just didn't want to cross that out until I ran it by the court in probation, but I would ask that be waived.
Well, this is not a plea, right?
No, sir.
Okay, so
No,
I
Your
don't think
Honor.
I really have a whole lot of control over those things.
Usually what we've done is waive it or not assess it.
Well, but it's an agreement that doesn't go through the court, right?
Well, that's
So if that's part of your agreement, I'm fine with it, but it's
If probation is fine with it, I am, because
it's PTI.
PTI, supervision costs, but if it's not a plea, I can't
Correct.
order that it be
That's-
done or
that's
not
fair.
done. It's part of the agreement.
from the state side, we have no objection. I just know that's the standard, but with the public defenders, I know most of them.
Well, but it's a restitution issue too, so it's probably best for the victim involved that the restitution be paid. Okay, I've reviewed it. It's not a plea, so I don't have to do anything as far as that. So Ms. Carroll, you all normally do a status date on non-plea PTIs? All right, so. All right, so Ms. Carroll, your PTI agreement's been taken by probation, it will be filed, so make sure you follow that agreement and you won't have to come back to court. All right, thank you, Ms. Carroll.
Seat over there.
Is she, are they gonna give it back? All right, put it on 8/25 for status for PT, for the PTO. We're just gonna put it on a status date of April. August 25th, just to make sure that PTI paperwork gets filed and processed.
Yes, Your Honor. Does Miss Carroll need to be there?
If the paperwork hasn't been processed, I'd like her to be there, but otherwise, I don't think it's needed. It'll be taken off. I can't imagine it's gonna take the better part of 2 months to get the paperwork processed. But. All right. Who do you have next, sir?
Tanisha Gadd, Your Honor.
Add.
24 CF 2791. Your Honor, we had this down as a plea or continue. It's still a restitution issues all the state and I need to work out in this case, Your Honor. We'll get it figured out, but I would ask for a continuance in this case so that we can reach out and get that figured out, squared
Okay.
away.
No objection, Your Honor.
All right, August 25th at 1 o'clock for pretrial conference so y'all can figure out that restitution issue.
Thank you, Your Honor.
Be back on that date, man. See you back on August 25th.
James Chad, Your Honor, we have this set for status 24 CF. You're fine. 2922. If Mr. Sheik and I may approach.
got this. Let's roll.
Fight fire with fire, take one.
Have you been injured in an accident and need righteous representation? Call us. Because we fight fire. Damn thing ain't working.
Not cool, bro. I'm Attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
All right, we're going to set Mr. James for August 25th at 1 o'clock. If he's still in his current location, he can appear by Zoom. Just give us a heads up on that, Mr. Maddox, if it's necessary.
Certainly, Your Honor. And in the meantime, I will move the case along.
All right, please do. August 25th, 1 o'clock. All right. Go ahead, Mr. Maddox.
Corey Kreider, 25 CF 177. Your Honor, the state's going to be getting me an updated offer in this case. It's plea or continue today. I would just ask for continuance.
No objection from the state, Your Honor.
All right, it's a new case. August 25th, 1 o'clock. Mr. Kreider will be back on that date. Stay in touch with Mr. Maddox. It sounds like there's a new plea offer coming.
William Lawrence. 24 CF 2858. Your Honor, I don't see him. This was plea or trial. I will check my notes to make sure he hasn't called and had some serious issue come up, but at this moment, I have nothing.
He would ask for a capias, Your Honor.
All right. And Mr. Lawrence will be a capias, no bond. Obviously, if he shows up or there's some issue, you can readdress it, Mr. Maddox.
Certainly, Your Honor.
It'll be taken off the trial docket. I mean, if he shows up later this afternoon, we'll reconsider that, but.
Jason McDowell. Your Honor, this is on the trial docket. However, the state and I have discussed it. We don't really have any difference of opinion in the way that this thing's going to proceed. If we could just set it for July 10th, I have no objection to the state's request for a continuance. I intend to subpoena the victim to that court date.
What is the 10th?
July 10th would just be the next date where we could.
It's mostly just a status to make sure. The state has had difficulty getting hold of the victim, and so we're subpoenaing them to make sure before we just dismiss this case.
What are we doing as far as the trial calendar?
Yeah, I have no objection to the state's continuance based on our discussions about it. If the court wants to leave it set up for trial, that would be up to the court, Your Honor.
It was a question, Mr. Maddox. You guys didn't really address that. You just said put it on the 10th.
Oh, yes, Your Honor, my apologies. Yes, that was just the nearest date where I feel like we could, my office was going to subpoena the victim. If the victim doesn't show, my understanding was the state was going to dismiss the case.
That is correct. So we would ask for a continuance, Your Honor.
Again, apologies, Your Honor.
No, I said, so you don't have to apologize. You didn't say
Well,
it.
it wasn't
so I
a
had to
clear
ask the
answer at all.
question.
I agree.
We just put it on the 11th, which is the jury review date.
Yeah, yes, Your Honor, that's fine.
I don't want to put too much on the 10th if we don't need it. 'Cause I think we've already put quite a few things on there, plus the arraignment docket.
No issues for me, Your Honor, with that.
All right, so it's no longer going to be set for trial, but we'll put it for July 11th, the jury review date, just for purposes of see if the victim shows up and wants to go forward.
Yeah.
All right, we'll see you back on that date, sir.
That was 9 a.m., Your Honor.
9 a.m., sorry, I did not say that. Thank you, Mr. Maddox. And that will be taken off the trial docket as well. James,
Thank you, Your Honor.
go ahead.
Tyson Odom, 24 CF 2948. Mr. Odom? He's present and approaching, Your Honor. Your Honor, I have a signed and executed pretrial intervention agreement. I've made the change accordingly, reflecting the $0 for the cost of supervision. Does the court need a copy?
Let me just take a look at it, and I'll hand it right back to you once I've looked at it. All right, here you go. All right, so it's a pretrial intervention without a plea?
Yes, Your Honor.
All right, so we're going to just mark it down for August 25th at 1 o'clock for purposes of status, that it's been, the paperwork's gone through. Otherwise, you wouldn't have to be there, Mr. Odom. Make sure you complete the terms of your pretrial intervention, or you'll have to come back for court.
Yes, sir.
Thank you.
Jason Peavy. Your Honor, this is Mr. Jason Peavy. He's present and approaching 25 CF 237. Your Honor, it's down for plea or continuance. I would ask for a continuance.
Just didn't work it out? I mean, are you going to set depots or anything else?
More or less, Your Honor. If that is what Mr. Peavy ultimately decides to do, then yes, I will probably do that. It's not necessarily in a very complicated case, Your Honor.
That's fine. I was just asking if there was anything in the works. August 25th, 1 o'clock. We'll see you back on that date, Mr. Peavy.
All right. Set an appointment. Sue Ragusa? Your Honor, this is Ms. Sue Ragusa, present and approaching for the court in 25 CF 89. Same thing here. Pretrial intervention agreement without a plea. May I approach?
Yeah, just wait up here a minute, and I'll take a quick look at it so you don't have to make 2 trips. All right, so Ms. Ragusa, I've reviewed your pretrial intervention program agreement. You're not doing that with a plea, but I'm going to give you another court date of August 25th. Just verify before you come to that date that everything's been resolved, paperwork's gone through. I don't need you there. It's just for status to make sure it's done that. All right.
9 a.m. What? 9 a.m.
1 p.m. I'm sorry, ma'am.
Oh, sorry.
But again, I don't expect that to be there. It's just really for us to keep track of it. All right. Thank you, Ms. Ragusa.
All right. Thank you. Dale Ursella?
Stella?
Your Honor, pretrial intervention agreement.
Same thing? All right, so Mr. Rosella, same thing you just heard me say to the last person. You're going to have to talk to probation. They're going to give you some instructions on how to do your pretrial intervention agreement. You're not doing it with a plea, but I'm just going to put it on a status date for August 25th at 1 o'clock to make sure the paperwork gets processed through, but otherwise I won't need you there.
Thank
All
you, Your
right.
Honor.
Thank you, Mr. Rosella.
Stay in touch.
Best practices things that I'm glad you brought up.
Andy Sheffield,
What's the current situation?
24 CF 2611. Your Honor, if we may approach on this case.
Sure.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Ms. Sheffield, we're going to have you come back on July 11th. That's our jury review date. You're not set for trial, but just kind of a status to figure out where things are at and if there's going to be a plea or not. All right, that's 9 a.m.
I'll continue working on it.
All right. Who's next, Mr. Maddox?
Sorry, Your Honor.
Who's next?
Robert Suttles, 25
Suttles.
CF 151.
Mr. Suttles here. Had his plea or continue?
Yes, Your Honor, that'd be correct. Mr. Suttles?
All right.
I got no information at the moment.
State would request a KPS, Your Honor.
All right, KPS, no bond for Mr. Suttles, but if he shows up, we'll take it.
Okay. That's another unfortunate one. Brian Threet. Your Honor, Mr. Threet, I've relayed a new offer to Mr. Threet. He's indicated he'd like a few minutes to speak to me a little bit further about it, if I could just have that few minutes pass him.
We'll pass it, bring it back up when you're ready.
Thank you, Your Honor.
All right.
Jason Colburn.
Say Colburn?
Colburn, yes, Your Honor. 24 CF 2578.
Go ahead.
Your Honor, I have a pretrial intervention agreement, same as the others here. No plea, if I could just approach with it for a 3-year review.
Yes, sir. All right, so Mr. Coburn, there's a pretrial intervention agreement that you've signed. It's done so without a plea, so I'm not going to take a plea from you. You just have to make sure to talk to probation. They're going to set you up with, how to go about doing what you need to get done. And then we're going to put it on a kind of a status date for August 25th, just to make sure all the paperwork gets processed. But once that gets processed, you won't have to be here. All right, August 25th for status on the paperwork that's here.
Your Honor, that's all the cases I had except for Wendy Ulrich, and I'm not sure the court had a copy of it, but that was my client who had reached out to the clerk of court, and I believe your office was advised.
Is she here today?
She is, Your Honor.
Okay.
I filed a motion to withdraw the KP, so I'm not sure if the court had an opportunity.
I've seen it, but
Okay.
I wanted to make sure she was actually going to show up.
That would be reasonable.
Mr. Maddox, what's the client's name? Okay, yeah.
Yes.
That was the one, it was a motion to withdraw KPS.
Sorry, I'm sorry.
Yes, it is 24 CF 2795. This is a case that Ms. Ulrich was not here for court on the 23rd. I issued a capias, and then Mr. Maddox had filed a motion to withdraw that capias. I'm trying to find that motion now. I know I reviewed it, but I just don't want to confuse it with.
I have a copy if the court needs it, Your Honor.
Let me see if I can, I know you emailed it to us. I'm just going to find it. All right. All right, so what was the issue? According to your motion, there was some car trouble?
There's some car trouble, Your Honor, and also she just got confused about the court date. She had it down for the 24th. As soon as she realized that mistake, she reached out to our office, she reached out to the clerk, and then made her soonest appearance that she could.
So what are we going to do with her case at this point?
Your Honor, I'd ask for a continuance in this case. I know it's getting fairly old. I have, per Ms. York's request, researched some things that she brought to my attention. I do believe there is some merit in what she's asking for. There is a possible motion to suppress, so I'm going to get depositions scheduled, Your Honor.
So let's withdraw the capias that was issued on the 23rd of June. I'll place her on August 25th at 1 o'clock. Motion to withdraw the capias is granted.
Thank you, Your Honor.
Thank you.
Did I send an order to the court, or does the court need an order?
You did.
Okay.
Well, hold on. I say that and then I'll set it for docket day today, but I'll sign it, but we've resolved that part. And again, August 25th at 1 o'clock. Make sure it's clearly on your calendar, Ms. Ulrich. And if you have problems getting here, to contact Mr. Maddox's office. Make sure they know about it because you could have been picked up in the past week.
I know.
So just make sure that you're handling those things.
Thank you so much, Your Honor.
You're welcome. Mr. Chamness, come on up. I think I just got the order for that too.
And I believe that's all my out of custodies, Your Honor.
All right, thank you.
I'll speak with Mr. Threet, though, about that plea and see if I can get him back up here if he wants to take it.
Let me find it. All right, Mr. Chamness. I believe, is it Mr. Powell had withdrawn from your case?
Yes, sir.
All right. Have you done anything to hire a new counsel, or are you asking for
No,
a
sir, I
public?
filled out the paperwork.
Oh, you did fill, you know what, I did see that, now that I think about it. Indigent, so I'm gonna go ahead and appoint the public defender's office for you. I did read it earlier, because the first one was just the one you filed, so with the bottom part where they say if it's granted or not was blank, and then I found the second one.
Okay.
So I'll appoint the public defender, this is Mr. Chamness, and it's 25 CF 673. Felony battery and an obstruction or tampering type charge. Mr. Williams,
Let me see if I can find it.
I believe it's.
Under Mr. Powell's. Do you have a docket number, maybe? Okay. Mr. Chamness,
Problem is, they're not always the same.
come and sit down with me and I'll find it, okay?
Yes, sir.
All righty.
So, but I don't believe he's ever even had a pretrial conference except for this past week where Mr. Powell was withdrawing, so I'm fine to put it on August 25th at 1 o'clock for you.
Yes, sir. It'll be Mr. Maddox's case, but
Okay.
I'll go ahead and appear for right now.
All right, so Mr. Chamness, you're going to talk, Mr. Maddox is going to end up being your lawyer. This is Mr. Williams. He's going to chat with you for a minute, but come back August 25th at 1 o'clock. All right, thank you.
And he has filled out an application, Judge?
Yes, he filled it out since last week. I did see it this morning. It was approved by the clerk's office earlier.
All right.
All right, thank you. Ms. Leone, Mr. Williams, you want to come up for a second? No, other Mr. Williams? Sorry.
Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
All right, hold on.
Backbone Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch, Monday through Thursday
All right,
from
Ms.
10
Rivers, I
a.m.
think
till
your 6 cases are all lined up. And just for everyone's attention, I think what we're going to do is try to get through as many cases as we can, but once Mr. Charles Williams' client is here to do the sentencing, I'd like to take that one as quickly as possible. So if there's anything you want to get done before that, make sure y'all tell us. So especially if you only got 1 or 2 cases left or something like that, I'd like to get everybody out of here that we can. Go ahead, Ms. Rivers.
Your Honor, this is Derek Lewis, 23 CF 2797. And speaking with Ms. Leone, we're still waiting on the FDLE results, so we're going to request a continuance at this time.
That's correct, Your Honor. We still don't have the FDLE from, for the DNA.
Oh, the DNA issue.
Yes.
And that was that y'all had asked to have done, right?
Yes, Your Honor.
All right, so what are you asking for, Ms. Rivers?
A continuance, Your Honor.
No objection.
August 25th August 27th at 9 a.m. for Mr. Lewis.
Yes, Your Honor. All right, I'll be out
He's on
once
our
I know
trial
anything
docket,
more,
I
okay?
believe, so I'm going to take him off of that.
Yes, Your Honor. Go to the next one, which should be Diana Malone. I can do Simmons. Yep. Your Honor, this is Bradley Simmons before the court on 14 CF 2669, 24 CF 2626. We've reached an agreement in this matter, if I may.
Yes, ma'am. Sorry, I just coughed in my. I thought I smelled it over here.
No.
Okay. We can do All right.
Nope.
How you doing?
Negotiate.
All right, so this is Mr. Simmons. Mr. Simmons, you're here in two different cases, 14 CF 2669 and 24 CF 2626. In the 24 case, it's possession of a controlled substance, third-degree felony, and then it's VOPs, or VOP on the other case. Is that correct? All right, Mr. Simmons, I've been handed a plea and sentencing agreement that will call for you to, I guess, admit your violation of probation, reinstate that probation with the same terms and conditions, and then in the new case, well, both, and it'll be 11 months, 29 days in Okaloosa County Jail, credit for time served, and then also in the new case, 1129 jail, credit for time served, and all of your fees and costs that are listed here. Is that what you want to do?
Well, how much fees? How much do I owe?
So, VOP. Mm-hmm.
So I still have my license to go to work, right?
Ms. Rivers, are we ready to go, or you need
Yes,
more
Your Honor.
time?
We're ready.
Mr. Simmons, do you need more time to speak with Ms. Rivers?
I'm trying to get something certified, you know, like.
Okay.
I don't do drugs, but I guess the stuff, I call them a car, so I guess I don't do drugs, but I'll be trying to work. I got jobs to go to, so I guess my license gets suspended. I pay all that money to get my license back, sir. But I got kids and everything, but I don't mind paying
Well, I'm
money.
not sure what the issue, I mean, he's going to be on probation, right? Can he pay his fees during probation?
He's
I guess technically he's on a probation on the 24 case.
He's referring to the 6-month driver's license suspension on the drug case, which he'll have to get a substance abuse evaluation, any recommended counseling if they deem so fit, and take that to DMV before he can get his license back or wait 6 months.
When I get out of here, I go straight to.
How much time is he going to have left?
He still has a couple of months left, Your Honor.
Okay. Well, see if you can maybe set it up on the outside, but, because that 6 months doesn't start until you're out of jail.
Got like 2 months left, right?
Mm-hmm.
Yeah. Just trying to make. I'm a little lost right now.
Well, then I'm going to go ahead and pass your case, Mr. Simmons, because it sounds like you've got more questions than I've got answers for you.
I want to double tonight.
We can call you back up later, but I can't have you saying I'm lost and confused.
I'm fine.
Well, you've already said it. So I'm not going to be in a situation where you come back later and say, I truly didn't understand this, and I want to undo. Mr. Simmons, if I could finish. I'm not saying I won't resolve your case later today, but I can't have you saying I'm lost, because then if I take your plea like that, and then you come back later and say, well, I didn't understand that, so now I want to withdraw my plea, we're going to have to do all this over.
I understand.
So I'm going to take the rest of Miss Rivers' cases. Then you can talk to her, and then I'll call her back up when she's ready to go after I've handled a couple more. I can't have people confused, or when I say you're making your plea willfully, knowingly, and voluntarily, it has to be true. Those aren't questions I just asked for to check boxes. All right, we'll call you back up, Mr. Simmons, but Ms. Rivers will talk to you in a minute.
Your Honor, this is Diana Malone. She's before the court on 21 CF 923. Last time we were in court, we had gotten the state had gotten their second evaluation completed regarding the not guilty by reason of insanity. We discussed having a conditional release plan in place. I have spoken to Gabrielle Balancier, and she is the one who does such things. She said she would have it to me by Friday. She did not, and I still don't have it. I would ask if we could get put on for next week.
I'm fine with that, because I'd like to see it beforehand too, because this is a little bit of a rarity. I want to call it unique, but rarity of a case. I mean, is the state basically stipulating to this, or what? You don't know what the
To the plan, Your Honor?
not to the plan, but just that the idea of there being a plan. I mean, because NGRI is that first it's not guilty by reason of insanity usually means there's a trial where that's determined. But I think what you're trying to do, Ms. Rivers, is have some sort of conditional release before that.
No, Your Honor, in speaking with the state, and she'll correct me if I misunderstood
That's
her,
what I'm trying to clarify.
there would be the anticipation that there would be a stipulation to not guilty by reason of insanity, since both doctors are saying that. And then we would proceed with asking the court to find her not guilty by reason of insanity, and then
Like
have
a
conditional
bench
release
trial,
plan.
or, I mean, how's that going to?
Conditional release plan.
But wouldn't that be, there has to be a trial to determine that.
I haven't in the past.
Well, I mean, I want to look at what you're going to supply, but that's a new one for me. I think I'd have to hear, I'd like to know more than just what the reports say, because frankly, I had some questions. I read both reports again yesterday. Well, I read the one you gave me last week, and I just saw the other one late yesterday. So I've read them both, but I've got some questions, I guess, potentially for the doctors. So let's set that for next week. You want to do the 11th?
July 11th.
Yes, that for next Friday
That
at
would be-
9 o'clock. That's the jury review date, so we'll all be here anyway.
Yes, Your Honor, that's fine.
But I'd like to see anything I can in advance on that. And Ms. Rivers, if you've got a case that you know you've done that on, just if you could send over an email with any case numbers, just so I can go back and look at those, because I went through the rule yesterday, I went through the statutes yesterday, and I'm not going to say that it's not accurate. I just, there's some left to be desired from those particular things I read yesterday as far as procedural. So just send that to me and I'll take a look. All right, so July 11th at 9 a.m., but this is not on the trial docket.
Is the court expecting either doctor to be present?
Not at that date.
Okay, okay.
But
Time to subpoena them. Right.
my concern is I want to make sure, I can see somewhere where this has been done this way that y'all are suggesting.
That's fine, Your Honor.
But also I want to know if I'm going to do that, what the concerns are, because I know part of the release plan talked about where she's going to live and with whom, and I read about her children, and I think one was local, but one's not, and there has been some absence. So I would really have to know some facts about that.
That's fine, Your Honor.
So once you get that report, if you could send it over to me.
There's two local.
Not report, plan, I
The
guess is
plan.
a better way to say it. Maybe that's the confusing part.
7th. Okay? All right. See you next week.
All right, thank you, Ms. Malone.
Your Honor, the next one that's listed on the docket is not here, and that is Jared Mullis, 24 CF 2840. I filed a waiver of appearance on his case.
Wasn't that the issue we were trying to find out if it had in fact been filed? That's why we left it on for today. That's what my note said,
Okay, I do not recall, Your Honor.
because you said you filed one, but
Yes, Your Honor.
nobody can seemingly see it.
I can make a note, Your Honor, to ask Sarah to send it.
I just want it to be seen, because apparently a waiver of his appearance was filed, but none of us can see it. It was just to verify that it had been filed, otherwise, if he's not here, we gotta talk about that.
Desmond Porter would be next.
Mullis,
We did a
he's
waiver.
not in custody.
He's not in custody, yeah, waiver of appearance.
You don't see it. If you could find whatever, a copy of maybe what if he filed it, just so we can make the record clear.
Yeah,
But
sure.
let's just, not where anyone else can see it.
With dismissal is when, if he pleads as charged.
When was it filed?
You misunderstood me.
This is fine. The new program has it filed on the 13th of June. So we're going to go ahead and put Mr. Mullis on August 25th at 1 o'clock, since he's not in custody. And we'll see you back on that date. Just make sure he knows that date to come back to.
Yes, Your Honor. Your Honor, the next is Desmond Porter, 25 CF 137. Your Honor, we've reached an agreement in this matter.
Okay. Yes, ma'am.
I misunderstood. Because
If there was nothing that's why
previously, the offer is the same. To plead to that.
Whose case is this?
Ms. Bassos.
Ms. Basso, Ms. Rivers, can you come up for a second?
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll.
Fight fire with fire, take one.
Have you been injured in an accident and need righteous representation? Call us. Because we fight fire. Damn thing ain't working.
Whoa! Not cool, bro. I'm attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath.
All right. All right, thank you. I just had some general questions about some issues. All right, but back to Mr. Porter, 25 CF 137. Mr. Porter, you're here on a failure to register charge, which is a third-degree felony, punishable up to 5 years in state prison. Do you understand that?
Yes, sir.
All right, and I've been handed a plea and sentencing agreement between you and the state that calls for you to plead no contest, 6 months of community control, electronic monitoring at $1 per day, 415 court costs, $100 cost of prosecution, $100 PD fee, $50 application fee, and waive cost of supervision due to the fact that you're represented by the PD and indigent. And it'd be an adjudication of guilt. Is that what you want to do here today?
Yes, sir.
Is that the state's agreement?
It is the state's agreement, Your Honor, and I believe the score sheet has been provided by Ms. Rivers.
Okay, and this would be a downward departure based on uncoerced plea bargain, is that right?
That is correct, Your Honor.
Okay. All right, Mr. Porter, have you gone over this plea and sentencing agreement with your lawyer?
Yes, sir.
All right, did you understand it?
Yes, sir.
And did you sign it?
Yes, sir.
Are you satisfied with your lawyer's advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues or concerns?
No, sir.
All right, has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
You understand that if you enter a plea, there won't be a trial of any kind?
Yes, sir.
And you understand you're giving up your trial rights, which are on page 1, going over to page 2 on your plea agreement that you signed?
Yes, sir.
And do you understand that you're waiving all potential defenses?
Yes, sir.
And do you understand that if you're not a citizen, U.S. citizen, this could lead to your deportation?
Yes, sir.
And what is your plea to the failure to register?
No contest.
All right, I'm going to accept your no contest plea as freely, voluntarily, knowingly given. Adjudicate you guilty, 6 months community control, electronic monitoring or a GPS monitor at $1 per day, 415 court costs, $100 cost of prosecution, $100 PD fee, $50 application fee, and waive cost of supervision. Again, this is downward departure. He scored 49.5 months, but this is an uncoerced plea bargain as the reason for the downward departure. What is that one? Okay, another 151. I'm going to need you to be fingerprinted, Mr. Porter, then meet with probation, and then you have 30 days to appeal the judgment and sentence.
Yes, sir. Thank you.
Heard of that one. I think a lot of times Anna just gives me the total, and I just say it, but it doesn't. So that's why I haven't just heard the 151. All right, what do we have next?
Your Honor, this is Chayton Truelove, 24 CF 60. When we were in court last, Mr. Truelove indicated he had some witnesses. We have provided the state with those witnesses. I have spoken to one of the witnesses, and based on the information that was provided to me, there appears to be some potentially beneficial and important information that could help his case, and I need to investigate it. And I was not able to get any type of answers on Friday.
Okay.
I am going to be asking for a continuance. We do anticipate trial next round, though.
All right. Whose case is this for the state? All right. Any
Objection based on the additional witnesses, and we ourselves would like to look into what they have to say and see if they need a deposition.
Have you been given the names?
We have, Your Honor.
Have they been put in a discovery exhibit or reciprocal
Your Honor, we
discovery?
did both. I personally sent Ms. Basso a copy of that last week, and then my assistant did the official discovery as well.
Just in case Ms. Basso wants to depose anybody, just like we talked about in an earlier case, they got to be categorized and all that. So you guys know that. I'm just kind of saying why I'm asking, because I want to make sure it gets done, because if you just filed it and then she may not get it, I'm just not very confident with the portal and e-service and those things right now.
Ms. Rivers is pretty conscientious about CCing me on things.
I appreciate that, especially in
that
these
reason-
trying times we live in.
And for that reason, I made sure to personally email her that information.
All right, so we're going to put it on August 27th at 9 o'clock for the next pretrial, but we expect it to be a trial next time.
Yes, Your Honor.
All right, thank you, Mr. Trullo.
Thank you.
Your Honor, this is Richard Wagner. He's before the court on 23 CF 2526, and we're ready for trial.
State ready?
No, Your Honor. I'm going to have argument 1 second. My only reason for saying no, Your Honor, is timing issues. I just want the court to be aware that it was released on an ROR after a motion for bond back on 4/18/24. The bond was revoked because he committed another crime. He was arrested for driving while license suspended and paraphernalia. The bond was reinstated again on 5/9, and he failed to appear at pretrial on 6/24/24. Since then, he knew he had failed to appear. His bond was reinstated twice. He made himself unavailable until he was arrested recently for the latest, very serious, 1, 2, 3, 4, 5 crimes.
5 cases.
Five cases, yes. Yes, Your Honor, you're correct. It's only 5 cases, multiple offenses per case. I don't believe that he should be given any priority in resolving this case that he himself has caused delay for. Obviously, his speedy trial doesn't apply because obviously he waived that. If he really intends on going forward on this case, he would have to file a demand for speedy trial, and that would give the states 60 days to take the case to trial. It's a very straightforward case, Your Honor. It shouldn't take more than, it could be a pick and go case. It's really time management issues that I'm asking the court to consider postponing it. I have other cases that the court knows are already set for trial, and they're older than this, and they have not caused the delay that this defendant has caused to himself.
Which ones do you have going still?
I have 2 with Mr. Williams. One is a burglary with battery punishable by life, and the other one is attempted murder. And one more, Nicholas Wallace. I don't know who has that. You?
Miss Rivers, and those are speedy trial demands, right?
That's correct.
All right, just to make sure it's clear, in all of his new cases, that's 25 CF 894, 895, 898, 899, and 902. He doesn't have bond in those either.
Right.
So it's not a situation that if this case were resolved, he'd be released.
No, Your Honor.
Ms. Rivers, your argument against their motion to continue.
Your Honor, my only argument is this. I mean, you ask if they're ready for trial. It's ready for trial, so we're ready for trial.
Well, Your Honor, there is, I believe that you have set the positions in this case.
We did depositions
No, on
last
the
year,
7th, I
year
think.
before.
Oh, that was the other case.
That's the
Never
other
mind.
case.
Sorry, Your Honor, that's my other argument.
No, depositions have been completed. This case is ready for trial.
Yes.
I guess part of my concern, Ms. Leone, and why I asked is I wanted to make sure that your other cases are actually going still.
The other cases are not his cases.
No, your other cases.
Judge, I can represent to the court that my last conversations with both clients this morning were trials. They've rejected the negotiations back and forth.
Because my understanding from what's already been set for trial, I know only 3 of them have come up before me and said they're ready for trial, but one of them is going to be a week-long case, and the other one's going to be a 2 to 3 day case, so I'm running out of time as it is.
I did have the 2 that Mr. Williams.
Yeah, and we've got plenty of more to still cross.
Right, yeah.
And so, Mr. Wagner, I'm going to continue your case over objection. It's my understanding from reading the file in this case, not just listening to what the state attorney said about it, but that bond had been revoked and then reinstated and then revoked again, and it took about 10 months for you to be found. So based on that, I'm going to go ahead and continue to the next trial cycle. That's going to be August 27th at 1 o'clock. Defendant's objection is noted for the record. And again, that would put out there, since he's got other cases holding him without bond that are set for the next cycle as it is, it doesn't really change a whole lot in practicality. All right, thank you, Mr. Wagner. Thank you, Mr. Wagner. You too.
Good morning. Your Honor, this is Nicholas Wallace. He's before the court on 25 CF 299, 25 CF 531. We are ready for trial. Yes, Your Honor, these are both speedy trials.
So, Your Honor, as I mentioned wrongly earlier in the other case, there are depositions.
Which case?
The case that we just heard with Mr. Wagner.
You said wrongly that there were depositions in his
Right.
case, but they're Mr. Wallace's.
Right.
Right.
Yeah,
We have
that's what.
depositions set for next week, Your Honor, so it'll be ready to go.
Or next week. However, the state is currently investigating additional charges of tampering because of the numerous jail calls that this defendant has been placing from the jail, notwithstanding and no contact with the victim order. The victim has communicated with our office about the pressure the defendant is placing on her to basically drop the charges. I haven't received the certified copies of those calls yet, but the request has been made. Additionally, we're still waiting for the medical records regarding the victim's pregnancy, since the defendant is charged with aggravated battery on pregnant person. And obviously, if there are still depositions set that haven't been done yet, I'm not sure how we are ready, the defense is ready for trial. And therefore, I believe that forcing a trial at this stage is not a showing of good faith.
My client's entitled to a speedy trial. He wants a speedy trial. I'd like to be able to do depositions beforehand, but I'm still willing to accommodate him in his request for a speedy trial.
When were the depots set?
They were set.
That's something you might be able to figure out from your file, because I just don't see anything.
No, Your Honor. The last time we had requested depositions from Ms. Leone, we were given 3 dates, the 7th, and then 2 dates in August.
I guess just for the record, was that a week ago you asked for that?
Oh, no,
3
no.
months ago you asked for that?
It was in between last pretrial conference and this pretrial conference. When I came to court at
Last pretrial conference was a week ago.
I know, Your Honor. When I came to court for pretrial conference, I had, the ones set that, for those dates, for the 3 dates.
Additionally, Your Honor, speedy trial expires for the case 299 on August 3rd, and on 25 CF 531, it's September 4th.
I understand. I don't have any more trial periods before then, though.
I'm just mentioning that it's not over, like we're not.
I understand, but what you're asking me to potentially do is put us in a situation, when I say us, I mean the entire division, in a situation where I don't have the time to give to a speedy trial because I have other things set for all of that time between now and then having to probably call in an extra judge or a senior judge to either handle the trial or handle what my normal docket is, but on those particular dates. I can't force things into a situation where it makes it more difficult just because the state may have too many cases set for trial. Frankly, I'm not sure if I want to jump into the fire of the speedy trial rule changing tomorrow and how that could affect pending cases if I don't need to. I mean, the way I look at it is there's a lot of cases set for trial. If I've got to get back up, so can everybody else. Any other argument you want to make, Ms. Leon?
My position is that he wants to go forward because he knows that the victim probably will not show up based on the phone call.
Or he wants a speedy trial because he's in jail and wants to have his day in court.
Well, if the jail is a problem, I'll be agreeable to a bond. That is the problem. It's a serious case. There are serious allegations. I don't want to just drop them. I haven't received the medical records yet.
I mean, this case has been pending since, what, January?
Yes, January.
And these records shouldn't take, 4, 5, 6 months to get.
That's what we have to face, Your Honor. Unfortunately, when we get medical records, it's the time for subpoenas.
I'm going to keep it on the trial docket. If y'all want to make any further motions based on what happens between now and the 11th of July, I'll entertain it. But
that's fine.
I can't just boot cases and put us into a speedy trial predicament just because there's might be a little bit more to do. Obviously, Ms. Rivers, if we get to that point, if giving him some sort of bond might relieve some of his concerns about that, I'll address that. But I'm not trying to make this some sort of deal that y'all are making with me. I just want to, if it happens, I'll certainly entertain those things if it's stipulated to. But otherwise, people have a right to a trial within 175 days unless there's good cause as to why not. And not receiving records, if the victim wants to prosecute them, then they could easily be obtained within a day or two. Anybody can go into a hospital with their doctor and say, give me a copy of my medical report, and they have to give it to them.
Oh, sorry.
But as far as, if you're concerned about a business record situation, but any type of consent or HIPAA issue can make that go a lot faster.
Well, I do have screenshots from the victim, but to go to trial, unless he stipulates to that, I'm ready.
All right, when did your subpoena go out for it then?
I can check for you.
These are important things. 175 days is not really a long time. So we have to realize that when the cases are coming in, about can they be done that quickly? And it's unfortunate. I mean, y'all have too many cases, and when I say y'all, I mean both sides of this. Someone I heard this past week made that kind of comment. The only lawyers who have no control over how many cases they take are the state attorney and the public defender. So I know y'all have a lot of cases, but I can't balance that against constitutional rights. It's a pretty easy balancing that goes in favor of the defendant.
I understand, John.
So, I mean, if someone files a motion one way or the other, talks about, how this can be resolved a different way, or that there's, due diligence couldn't have got it done in time, I'll entertain all those things on the 11th. But until now, I think we have to be ready for trial all around. All right. As far as the 299 case, how long do you think that would last?
I can ask the cases are against the same victim. We cannot do a motion to consolidate, so we can do it at once.
Are they from the same instance?
No, Your Honor.
No, but it's the same course of conduct. It's the same victims.
File your motion to consolidate, and I'll consider it. But again, I'm not saying I would grant it or deny it. I just don't know. Y'all have the advantage on me. I don't know the facts of cases when they come in front of me until we get to the point of it's a motion hearing or it's a trial. I think if I knew too much about the case already, you guys would claim I'm biased about it, and rightly so. But the only thing I ever get to see or read is the arrest report, because it's in the court file. So I don't know what's the same course of conduct or not, because no motion's been filed explaining that. It's one of those things, you can consolidate them or not, but then there's Williams' rule trying to get in all the information about one versus the other. But I still got to follow all the rules.
I have a question about the court records show that he's charged with a felony battery, but he's not.
Dave come out to.
Because the information
sizes.
filed, so I'm wondering if the information filed calls for aggravated battery on victim pregnant, which is a second-degree felony.
Victim pregnant, and then I'm showing the 531 cases, felony battery in violation of pretrial release conditions.
Right, but what I'm saying is that I have the information that I filed, prepared, called for count 1 to be a second-degree felony, ag battery, and not felony battery.
Okay,
Is it
so
fixed?
it's just in their system, it's like that.
Oh, okay.
Let me look at the information. Yes, the information filed in the 531 case on April 3rd says aggravated battery, so it's just wrong in how it got put into the clerk system, but the information is correct.
Thank you.
All right, and then, Mr. Wallace, you understand you're charged with 2 second-degree felonies and a first-degree misdemeanor, which means you could do up to approximately 31 years in incarceration based on these cases? Okay. And has a plea, I'm not asking what it is, but has the plea offer been conveyed, if there was one, Ms. Rivers?
Did we discuss the plea offer? Yes, Your Honor. And he told me what the plea offer.
Okay, so, and it's been rejected by him. All right. I'm going to keep them both set. Again, I'll entertain anything that comes in, but speedy trial is a constitutional right, and it's in the rules. And again, I know it's changing, but it is what it is as of right now. All right, so we'll keep those both on the trial list.
Do you know your sizes? The interview, I need to get his sizes.
But again, I'm going to start putting everyone on notice that's kind of here. If we get so many trials, I have to get backup judges. You're not really guaranteed what particular judge handles your case, and so we'll figure that out on our end and assign them as need be. This is, we've been through 3 jury trial cycles already since I took over. We've had 1 trial. Now it's looking like we're going to have at least 6. This is why I didn't want to keep pushing them off the past couple of times around. All right.
Here's this is Ms. Barrickman's case. It was set plea or continuance. I've talked with Mr. Booker. I've talked with Ms. Barrickson. I have filed today a bond motion for no, excuse me, that's the next fellow that I filed that on. Sorry, I flipped the page without looking. But on Mr. Booker, I'm going to have to move to continue.
I'm sorry, Mr. Williams, did you say you filed a bond hearing?
That was from the next page.
I flipped the page and I didn't look at the name.
State has no objection to continuance. We would note there was a motion to consolidate that's unopposed that was sent to your Honor's office last week. And there also a motion to unseal DCF CPT records. So I'll get those over to you.
Okay.
And Judge, the motion.
Again, just putting it out there, if you feel you're not getting those things in a timely fashion, make sure you follow up, because either we may not have received it or I may have signed it. I know there was at least one case I can cite off the top of my head that I'd signed the order more than a week earlier and people were still asking where it was. So it's just, the system is what it is right now. All right. So, Mr. Booker, do you understand the continuance?
Yes, sir.
Okay. 8:27 at 1 o'clock.
Judge, you mean at 9 o'clock?
9 o'clock, you're correct, sir.
All right.
Thank you, Mr. Booker.
Judge, Mr. Keaton's case is going to be complete.
Ms. Barrickman, is that your last case?
Yes, Your Honor.
Yes, sir. That's what we're doing. I'm out of order.
That's what I figured. And then we're going to take the Whittington matter, I think. Is the 21 case, is that a VOP?
Yes, Your Honor.
Okay. Oh, I see it now. So it's a failure to register with a VOP. All right.
Yes.
Mr. Keaton, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. Mr. Keaton, you are here in 21 CF 2013 on a violation of probation and 25 CF 472, which is failure to register. That's a third-degree felony, punish up to 5 years in state prison. Do you understand that? All right. And I've been handed a plea and sentencing agreement that would have you admit the violation of your probation in 21 CF 2013. And then in 25 CF 472, you'd be pleading no contest as charged. It'd be 24 months Department of Corrections, 515 court costs, 150 PD fee, revoke and terminate probation, and so you wouldn't have probation once you were released from your 24-month sentence. One thing I'd like to specifically point out is it says each count is concurrent but not coterminous, which means your time would be served at the same time, but if you've got more credit in one than the other, whichever one you have less credit in would be your controlling date for release from the Department of Corrections.
Yes, sir.
You understand that?
Yes, sir.
All right. Did you go over this plea and sentencing agreement with your lawyer?
Yes, sir.
Did you understand it?
Yes, sir. Yes.
All right. Did you sign it?
Sir.
And are you satisfied with your lawyer's advice and representation?
Yes, sir.
All right. Is this the state's agreement?
It is, Your Honor, and it is a downward departure based on a negotiated plea.
Okay. Lowest permissible prison sentence, Mr. Colton, was 75.3 months. So the only reason I can do under that is because the state has agreed under a plea bargain to give you 24 months. You understand that?
Yes, sir.
All right. Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues or concerns?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea? Has anyone promised you anything in return for your plea?
No, sir.
And do you understand that by entering this plea, there won't be a trial of any kind in the new case?
Yes, sir.
And you understand you're waiving your rights to trial, which are on page 1 and into page 2 of the agreement you signed?
Yes, sir.
And do you understand that on the VOP, by entering admission to your violation of probation, there won't be an evidentiary hearing where the state would have to prove you violated your probation in the ways they've alleged?
Yes, sir.
And do you understand that you're waiving all potential defenses to all of these counts?
Yes, sir.
And do you understand it's a felony conviction on these, so they're felony convictions?
Yes, sir, I do.
All right. And do you understand that if you're not a U.S. citizen, this could lead to your deportation?
Yes, sir.
All right. What is your plea to the violation of probation? Are you admitting or denying your violation of probation?
I'm admitting.
And as far as 25 CF 472, the failure to register, what is your plea on that charge?
No contest. Yes.
All right. I'm going to accept your no contest plea in 25 CF 472 and your admission in 21 CF 2013 as freely, voluntarily, knowingly given. It's going to be adjudication of guilt on all counts, 24 months, Department of Corrections, with credit for time served. Well, actually, it doesn't say that. I'm assuming that credit for time served is meant.
That's correct.
It says each count concurrent but not coterminous, but it doesn't actually say credit for time served. I'm saying it, credit for time served. But credit for what you have on each case.
Yes, sir.
All right, 515 court costs, 150 PD fee, revoke and terminate the probation. No supervision is to follow. Are there outstanding monies owed on the probation? If there are, they'll be sent to judgment. All right, again, this is downward departure based on uncoerced plea bargain with the state. And then I need you to be fingerprinted, Mr. Keaton, and you're going to have 30 days to appeal the judgment and sentence of this case.
Okay.
Subsection 14. Do you have a copy of my information? Internet identifiers. That's correct.
Thank you, sir. Need to be fingerprinted. All right. It's my understanding is that you're done, Ms. Bergman? Of course. All right. That we're going to break into our normal docket in order to handle the Whittington case, which we've had to continue once previously because we ran over time, and I don't want to do that again. I know we've had several people here in the past for it. So let's go ahead and call Whittington. Can I have the lawyer's approach, please? No, I'm sorry. Ms. Leone and Charles Williams. This is going to be State of Florida versus Landon Whittington, 23 CF 2875, 2876, 2879, and 24 CF 444. Ms. Leone is representing the state. Mr. Williams is here with Mr. Whittington, who's present. Correct me if I'm wrong. I believe a plea was entered back on May 5th with an agreed upon sentence. But we're having the sentencing hearing for those affected by the cases to be heard. Is that right?
That's correct, Your Honor.
All right, Ms. Leone, did I get that right?
Yes, Your Honor.
Okay.
Could you please?
I'm turning on the Zoom right now.
Yes, thank you. Then.
1 2 3 4 5 6 7 8 9 10 11 12 13 14 15 16 17 18 19 20 21 22 23 24 25 26 27 28 29 30 31 32 33 34 35 36 37 38 39 40 41 42 43 44 45 46 47 48 49 50 51 52 53 54 55 56 57 58 59 60 61 62 63 64 65 66 67 68 69 70 71 72 73 74 75 76 77 78 79 80 81 82 83 84 85 86 87 88 89 90 91 92 93 94 95 96 97 98 99 100 101 102 103 104 105 106 107 108 109 110 111 112 113 114 115 116 117 118 119 120 121 122 123 124 125 126 127 128 129 130 131 132 133 134 135 136 137 138 139 140 141 142 143 144 145 146 147 148 149 150 151 152 153 154 155 156 157 158
Your Honor, would you like me to announce the case numbers we're here for?
I announced the case numbers. I didn't go through all the counts, but.
Fine, Your Honor.
And Ms. Leone, Mr. Williams, I have Mr. Tyree, who was here present earlier, based on maybe some confusion on time zones. He's present, but I haven't brought him into the room yet until you tell me you want him.
Yeah, that's fine.
Now?
Yes,
Okay.
sir.
Is he going to be testifying?
I don't believe so.
Okay, so he's just witnessing. All right, Mr. Tyree, can you hear me okay?
Yes, sir, I can.
Okay, I just want to make sure you can hear us before we get really started and find out that you couldn't hear us the whole time. So it's my understanding from the state they're not expecting you to testify, so if I just put you on mute, if you are called to testify, obviously unmute, and we'll carry on from there.
Unless, Your Honor, if I may, he was one of the officers involved in one of the incidents. I just want to ask him if he wants to make a statement.
Oh, I'm sorry.
or not.
Okay, I got that wrong. That's my fault, Mr. Tyree.
I'll make a quick statement just on behalf of the families that are affected, if that's okay.
Okay, and if you could give me your role in it, I'm not familiar.
Yeah, so I'm a detective with Hendricks County. It's an agency in Indiana, Hendricks County Sheriff's Office. And we had 3 incidents involved Mr. Whittington's actions and his swatting calls to a couple residences, or about a couple residences in our county.
Anything else you want to tell us, Mr. Tyree?
Is this the time you'd like me to make the statement, sir?
Is that what you're asking for, Ms. Leone?
Yes, Your Honor, if you would like, yes, that's
All right, go ahead, Mr. Tyree.
fine.
Okay. I'll just make a quick statement. I've got some training that I need to get back to, if that's okay.
And I apologize for the delays, Mr. Tyree. That's on me. So.
I certainly understand how the court works, sir, yes. So just on behalf of, obviously, the Hendricks County deputies that responded to these very dangerous situations, as well as the Sharp family and the Street family, that that Mr. Whittington's actions terrorized. I just want to thank Okaloosa County for investigating and prosecuting these cases. I just sincerely hope that Mr. Whittington accepts his punishment and he's able to change his ways and be a productive adult. So I do appreciate your time.
All right, thank you, Mr. Tyree. Any questions for him from either side?
No, Your Honor.
All right.
No question.
All right, thank you, Mr. Tyree. Again, you're welcome to stay if you just want. Oh,
Before you excuse me, Your Honor, my client would like to say something briefly too.
well, he'll be able to hear still, but
Oh, okay. I just wanted to make sure if he left, he wanted it passed on to the victim, so.
okay.
Okay. If it is okay, Judge, I do have some training that I
Okay.
can get back to.
I understand.
All right, if you want him to make that statement specifically to the Indiana
Sure.
people who were involved, I'll let him do that, and then Mr. Tyree,
It won't take
I'll allow you to go.
won't
I'm keep
take
calling
but
you Mr., I'm sure it's detective or something like that, but I didn't want to misrank you.
It won't,
I understand, Judge.
All right,
it won't
thanks.
take but a moment of your time, Mr. Tyree. Go ahead, Landon.
Sure.
I would just like to say that I apologize to you, for the families involved, and for all the time I wasted of your time, and all like the families that were scared in it, and all the time I wasted down here that was involved in investigating this. And I just will send this punishment will set me straight. I will not be back in the courtroom ever again. And I do sincerely apologize.
Thank you, Your Honor.
Well, thank you for that.
All right. And thank you, Detective. If you're free to go, you're free to stay. I'll just keep the Zoom on if you're here.
Thank you, Judge.
All right, thank you. All right. Ms. Leone, what else would you like to present?
I would like to call investigator Misty Piaget to the stand to make a
Come
statement.
on up.
You know, prior to investigators starting, probably, may I publish a brief interview is the officer responding on one of the scenes. It's only a total of approximately 10 minutes.
Okay.
Just the video.
No objection.
Let's see how this is going to work. All right, your screen's up.
Oh, okay. Great. It's gonna show 30.
Oh, I'll get
Sorry.
that.
It's gonna show 24 minutes. I'm only playing from minute, the initial few minutes in the beginning.
You expect sound before the 30-second mark? I just want to make sure if the
I
sound's working.
know, Judge. I
That's-
don't
Sir, I see another person in the house moving. Want me to move up? Ronnie, put your hands in the air and walk towards the sound of my voice. Ronnie!
I'm sorry.
He walked back in and shut the door with his feet. Shut the door with the female appears to be behind it.
You want a spotlight on?
Yeah.
Yeah, I got you.
You contact county SWAT. I have one looking out the rear of the. So we can assist you. Since you got him in the back, I hear you talking. I'm talking to somebody named John Sander at this residence.
Go on, let's go. I'm behind you.
I'm 40 coming to you. Hey, Lynn.
Yep.
Sir, keep your hands up. Keep your hands up. I'm coming to you.
Okay, I hear you. I'm all good. I got a guy over there.
Who else is with you?
The wife is right behind me, and I'd
Just
rather
hold
have her
keep your
not
hands up.
Get to be cops.
Keep your hands up. Keep your
My
hands
hands
up.
are up. I just got home from dinner. What's happening? Tell me what's happening.
Yes, could you step out, man?
Why are you handcuffed?
Step over here to him. Yes, you have to. You have no choice. Come on.
What is going on?
Try to take you from there.
His hands.
Turn around.
What is happening?
There's nobody in around in this restaurant.
I don't think so. And they just got home.
We were
I got home
at dinner
5 minutes ago.
Okay, just relax. I apologize for this, but
No.
Scared the shit out of me.
I'm having
there's nobody else in that house. And your address is 4 Brooksby.
Yeah.
4 Brokey Drive.
And the other address, I'm not remember what it is.
Can we just step down so I can wait?
Sure. So here,
What
I'll tell you
floor
this.
you in?
I'll tell you this. You can go in there if you want.
Go in the house.
Go in the house. I'm giving you permission.
Over here.
I'm giving you permission to do it.
I have an issue if you want to come back.
No, this.
Is anybody? Both parties are the same.
We're gonna walk over here. We're away from the house, okay? There's nobody else inside?
I'm with
Cat, this should not be outside.
We have cats that shouldn't be outside, but they're going outside. Whatever.
I can't, I'm having palpitations.
And then, Your Honor, I'm going to switch to minute 13 to 15.
Steve, come on now. Get her out.
I gotta drive with you.
He's I see guy getting released.
I'm just gonna leave my car with him. I'm gonna drive over to somebody else.
He's in the car with me.
Okay. We're gonna release him. We're gonna take him out.
All right, take him out. Take him out. Take him out. Take him out.
Yeah, real. Did anyone check the shed back there? He's saying there's a shed, but somebody could
My shed is right there. Can't miss it. If the rock is not in front of the shed, somebody's in the shed. Now, there's a creek that runs from house to house. It's 3 feet deep. 3 feet
I'm
deep.
gonna explain. You come out. I'm gonna explain
Okay,
everything.
just telling you, in case you haven't looked, that's where you gotta look. Oh my God. Oh, that hurts the hands.
I'm gonna let you go.
Come right with me.
Yeah, I'm gonna let you out. Walk here with your wife.
Oh yeah, how's my wife? I'm worried about
One more. Minute 19.
Probably just a random incident. I will have one of my officers is going to get your name and phone number, and wife's name and phone number, and there's going to be a report written for it. Okay. And then we're going to kind of go from there and do our own investigation. So one of these officers will grab your information, and then you guys will go back and try. Sorry, that's it. Okay. All right. No. Just be ready. Do what you got to do. You all right?
I told you I wanted to explain. You know,
You get the fun job, huh?
Yeah.
All right, John. J-O-H.
Are you John or Jonathan?
John.
Okay. And your last name?
S-A-N-D-R. All right, sir, just senior. Just so you know, when they called in, the caller called in for Brothy. Brothy is what he said, Brothy Drive, which indicates somebody that's not familiar. If you live at 4 Brophy Drive, I know. You're calling in 4 Brophy. The caller called in and said he was at 4 Brophy Drive, which indicates somebody from out of the area calling in a swatted call. There you go. So we're gonna have it came from a 610 number. That's we're now going to get that. Pennsylvania. Yeah, Philly area.
That's it, Your Honor. That's all I wanted. Investigator, please state your name for the record.
Investigator Misty Piaget?
Now, you were involved with the investigation of this case.
Yes, ma'am.
Can you briefly explain, because we only watched some parts of this video,
Yes, ma'am.
who the people were? I think it was Mr. Sanders and Mrs. Sanders from New Jersey.
Yes.
And you've had the chance to review their interviews.
Yes.
From reviewing the interviews, how do you think this event has affected their lives?
They were very traumatized. Still to the last time I talked to them a couple of weeks ago, they're very traumatized still.
And is there anything that you would like to state for the court?
I have a small impact statement on behalf of the victims and the community, if that's okay, if I can read. I want to say, Your Honor, thank you for the opportunity to speak on behalf of many victims and communities deeply affected by the defendant's actions. The swatting incidents committed by the defendant were not isolated or impulsive. They were deliberate, calculated, and repeated, with full awareness of the chaos, fear, and trauma they would unleash. The defendant didn't just expect this reaction. He sought it, using fear and emergency response as a form of entertainment. These hoaxes targeted multiple private residents across the nation, as well as a high school in Texas, a place where children should feel safe, where teachers dedicate their lives to education, and where families expect protection. This false alarm amplified a fear in horrifying ways. To those affected, it wasn't a fake threat. It was a lived experience, terrifying and traumatic. Victims from across the country, families suddenly confronted by heavily armed officers, students witnessed chaos within their school, and innocent people forced to comply with high-stress police commands, endured the traumatic consequences of the defendant's actions. These are real people whose lives were disrupted and whose sense of safety was stolen by deliberate deception and cruelty. What's important to recognize is while these threats were false, the emergencies were real, the fear was real, the response was real, and the harm, emotional, psychological, and was also devastatingly real. This was a dangerous exploitation of public safety systems and a direct threat of the well-being of the entire communities. The defendant's actions caused a widespread fear, upended lives, wasted precious resources, and left students, families, and individuals across the nation traumatized. Thank you for taking this matter seriously, and thank you for recognizing the true harm these crimes have caused. I really, truly hope the defendant has learned from his actions and is able to rebuild and retaliate from there.
Thank you, Ms. I don't have any other
questions.
No, Your Honor.
Thank you.
Other witnesses, Ms. Leone?
No, other witnesses.
Williams, anyone that you want to have testify?
Your Honor, I think.
Make a statement. It's not really.
I think my client would like to address the court. It'd probably be very similar to what you already heard, but just for the record, he'd like to address you.
Go ahead, Mr. Whittington.
From my 20 months of being in the county jail, that this matter has showed me it is very, very, serious. And I was 14 whenever these occurrences happened, and now I'm 16. I've had plenty enough time to dwell on it, think about it, and know that they were not, good action. They were very ignorant and childish of me. And in this punishment that I'm having to go through is going to change me and not lead me back in the same place that I am in a couple of years. And I do apologize to you, to investigator behind me. Yeah. And I apologize to everyone involved in the matter and of what my actions have occurred.
Any other questions for him? Okay.
That's all I have, Your Honor.
Anything else that needs to be said? I mean, this is an agreed upon sentence. So, although we're having a sentencing hearing and these victim impact statements, which are very important for the court to hear, are certainly going to be and were, there's not really a decision for me to make. But I think some things need to be said. Mr. Whittington, if you're aware, if you remember, it was 20 months ago, but you came into my courtroom in juvenile delinquency when this first started, before you were charged as an adult. And so I had a little bit of background with it from literally the jump in this case. And it seemingly, I'm not going to say this had a causation effect, but it seemed like we then had a rash of these types of cases over the next 6 months or more, where it seemed like another juvenile here in our county was doing something not anywhere near as severe as what I've heard here, but similar things about making offhand comments that turned into concerns about threats and potential emergencies. And I've said numerous times while I was in the delinquency court that this is becoming a problem. It's not an epidemic at that stage, but it's a problem that it has grown. And from what I've seen, it's tapered down to some extent. Maybe people finding out that the court system and the judicial system, the law enforcement is taking these things very seriously. And at the age of 14, you went into a county jail and will serve a total of 4 years, basically giving away your teenage years for what amounts to what you thought was a stupid prank. But to the people of this state, Indiana, New Jersey, Texas, where people were afraid for their lives, I can only imagine the feelings of having numerous heavily armed law enforcement officers appearing at my home, being pulled out in the middle of the night for what turns out to be a teenager's prank. And that's from someone who has law enforcement officers sometimes showing up at my front door in the middle of the night for purposes of work. And that still would have been a very shocking, traumatic experience. These are not games. These are real people. This is not a situation where things happen in some bubble in some other place and it never comes back. But one of the things that really stuck out about your case from the beginning, Mr. Whittington, is I believe, and correct me if I'm mistaking this with another, but I believe it's Mr. Whittington, is that there was Google search history or internet search history that talked about where you researched how much prison can I get for swatting, which shows me that what you did, you knew it was wrong. And not just can I get in trouble for it, but how much prison can I get for it? And I've remembered that for probably the same 20 months you're talking about being in jail. Because it shows a willingness to do wrong even when you know it's wrong. And that's a lesson that you need to learn while you're serving your prison sentence. That doing harm to people, knowingly harming people, and doing it anyway is a special kind of evil that cannot exist. Prison is for a place. It is a place for people who, not just that we're mad at, but we have fear of. And you've put fear in the hearts of citizens of this county and other states. And that's why you're getting the sentence that you're getting. But at the same time, you know, the agreement between the state and you was for the youthful offender sentence with the 4 years of prison and 2 years of probation. That's in the plea agreement. And that's done because we understand, and the court system understands through the youthful offender sentencing structure, that people's brains are not fully developed at 14 or 16 or 18 or even 20 years old. In fact, the science really says it's more, especially in males, more like 25. And so had you done this when you were an adult, and certainly over the age of 21, and you weren't looking at youthful offender, Ms. Leone, any idea what he would have scored?
Yes.
I want to make sure you get an answer.
Yes.
As to how much prison you could have got. And if you've got the guidelines, what the maximum sentence could have been as well.
Least permissible months, maximum exposure 188 years.
That answer your question, Mr. Whittington? So I want to make sure that you, and just to make it clear, I'm sure the state, in line with Marcy's law and the Florida Constitution, talked to all the victims of these cases and about what ultimately the sentence would be. So I want to make sure you understand that your minimum sentence was about almost 8 years, 7.5, 8 years, minimum. And your maximum was obviously a de facto life sentence. And it's only through their compassion, forgiveness, that you're not doing those things. And so these are people you harmed. But they still were willing to give you the chance to make a life for yourself. Anybody else want to be heard?
Nothing from me, Your Honor.
All right, so pursuant to the plea and sentencing agreement that was entered on May 5th, I'm going to sentence you to 4 years in the Department of Corrections, followed by 2 years of probation. Just understanding that that's the maximum allowed under the youthful offender sentencing criteria, that a total of 6 years with a maximum of maximum of 4 years in the Department of Corrections. So you'll be getting the 4 years in the Department of Corrections, followed by those 2 years of probation. I believe there were other terms. I'm trying to find them in the plea and sentencing agreement. They're towards the back. A letter of apology to each victim, mental health or psychological counseling. It says, or comply with ECLC if he's going to DOC. I'm not sure that's really available going forward. Maybe in the probation. Okay. Restitution will be reserved for a period of 180 days. No electronics except for school purposes. That means nothing that can reach out to the internet for anything other than school purposes while you're on probation. No drugs or alcohol. Obviously, that's pretty self-explanatory because you won't be old enough to do those things anyway. And obviously, if we're talking about illicit drugs, you're never allowed to do that, just like no one else is. Did I miss any of the other? Oh, no contact with any co-defendants directly or indirectly. Also, no contact with the victims directly or indirectly, unless asked for in writing, which I would doubt would happen during the course of this case. Have I missed anything, Ms. Leone?
I don't think so.
Mr. Williams?
No, Your Honor.
All right. Mr. Whittington, I need you to be fingerprinted. You're going to have to talk to probation, even though you're going to a DOC sentence. You will be on probation when you are released. So they'll give you some ideas, but instructions, but at the same time, sir. Okay, so you don't need to talk to him at all? No, sir. Okay, all right, I just want to make sure. Usually that's, I think, somewhat explained to him while he's talking to you, but that's fine as well. All right, so I'll need you to be fingerprinted, and then you're going to have 30 days to appeal the judgment and sentence of this court. Clerk. On the misdemeanors, time served at this point, since he served more than that time, and I don't think I mentioned court costs. You were appointed, correct?
I was, Your Honor.
All right, so it's $50 cost of defense application fee plus $100 per case. And then court costs, $515 on each case. All the cases will be concurrent, prison and probation. Credit for time served. Mr. Whittington, take your opportunity that was given back. Thank you.
And with regard to Mr. Valley, Your Honor,
Okay.
I think it was very close.
All right, is this a copy?
No, that's the original.
That's the original, because it's all in black ink, so I'm going to give it back.
Right, I just wanted to.
This is why I never use black pens anymore, so I wanted to be clear that. All right, so this is, can you announce the case? Mr.
Yeah,
Manning?
Your Honor, State of Florida versus Corey Valley, it's 23 CF 1996, and Mr. Valley is here with me. We're here today, Your Honor, as you recall, I believe it was last Monday, there was some question arose as to whether Mr. Valley actually qualified as being indigent and therefore to have a court-appointed attorney represent him. You requested that I go see Mr. Valley and have him fill out a new indigency application, which I did, and the clerk has determined him to be indigent. So I think that's basically all we have today. I believe we are set to come back on the August cycle already.
Okay, so we're already set for August 27th at 9 o'clock. I will find that Mr. Valley is indigent. I know there was some confusion. I've seen the new application based on it. The clerk has found him to be indigent. I reviewed it. I think he's indigent. As we talked about both before and after that determination by the clerk, it was very close. But he is appointed counsel. I know previously the PD had been appointed, then RCC, and now you, Mr. Williams. So is there anything else that you need from me?
That's all we had in this matter, Your Honor.
Okay. All right, Mr. Valley, we'll see you back on August 27th at 9 o'clock.
And I believe
Do you have any others on the 9 o'clock docket? I think the only person you have left is maybe Rivera.
Mr. Rivera, yeah.
All right, well,
I believe
we've got to finish some other cases first because he was an add-on for purposes of this issue, and I've got, we've got a 9 o'clock, this is my docket day. We're trying to set cases for trial and things. We'll get back to you.
I just know that Ms. Bosal was waiting, so.
Okay, we'll try to get to you as quickly as we can, but at the same time, I can't put off the other 30 cases or so that I've got for an add-on that was just put here a couple days ago. All right, thank you. All right, Mr. Simmons.
Your Honor, I've spoken with Mr. Simmons. I believe we're ready.
Okay, thank you. You have the paperwork. All right, so this is Bradley Simmons, who's here in 14 CF 2669 and 24 CF 2626. The 24 case is possession of controlled substance. The 14 CF 2669 is a VOP. Mr. Simmons, I think I've already sworn you in and asked you some questions. Maybe I didn't, actually.
Yes, sir.
Okay, let me just make sure. Raise your right hand. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, and can you state your full name and date of birth?
Bradley Mirandale Simmons, 11/18/87.
All right, and Mr. Simmons, I have been given a plea and sentencing agreement. We had talked about it a little bit earlier, and you said something about being lost or confused about some issues. So hold on. So we took a little bit of break. You went and talked to Miss Rivers some more in the back, and she says you're ready to go. Has she answered all of your questions?
Yes, sir.
Okay. I've been given a plea and sentencing agreement that calls for you to enter an admission to the violation of probation. You'll get 11 months, 29 days in county jail, credit for time served, concurrent with your 24 case. Reinstate your probation with the same previous terms and conditions to complete, waive cost of supervision, $100 cost of prosecution, and $100 PD fee. In the 24 case, upon a no contest plea, it'll be 11/29, credit for time served, 5/15 court costs, $100 cost of prosecution, $100 PD fee, and a $50 application fee. Is that what you're looking to do today?
Yes, sir.
Okay. Is that the state's agreement? It is, Your Honor. Okay, and I'm looking at a guideline, sentencing guidelines that has a lowest permissible prison sentence of 122.325 months.
Yes, Your Honor. Just to put it on record, I believe the defendant originally on the first charge was sentenced to 122 months. And so that's a big reason why we have the downward departure in this case.
Okay. So that even if I gave him 122 months guideline sentence, it would still virtually be the same?
Yes, Your
Honor. Other than a couple of more months that the 11/29 puts on, right? All right. And Mr. Bradley, I'm sorry, Mr. Simmons, Bradley's your first name. Mr. Simmons, did you go over this plea and sentencing agreement with your lawyer?
Sir?
Did you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Are you satisfied with your attorney's advice and representation?
Yes, sir.
And are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues or concerns?
No, sir.
All right. You hesitated for a second. Are you?
No, sir.
All right, I just want to make sure. All right, and has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea?
Sir.
And do you understand that by entering a plea to the new charge, that there won't be a trial of any kind, and you're giving up your trial rights, which are listed on page 2 of the agreement that you signed?
Sir.
Do you understand that in the violation of probation, by admitting your violation, there won't be an evidentiary hearing where the state would have to prove that you violated your probation? You understand?
Yes, sir.
Okay, and do you understand you're waiving all potential defenses that you may have across these two issues?
Sir.
And do you understand that these are felony convictions?
Sir.
And so do you understand that if you're not a U.S. citizen, this could lead to your deportation?
Sir.
All right. As to 24 CF 2626, the possession of controlled substance, what is your plea?
No contest.
All right. And as to 14 CF 2669, what is your plea to the violation of probation? Are you admitting or denying the violation of probation?
Admitting.
All right. I'm going to accept your admission to the VOP as well as your no contest plea in the new case is freely, voluntarily, knowingly given. In the 14 CF 2669, sentence you to 11 months, 29 days, credit for time served, concurrent with 24 CF 2626, reinstate your probation with the same previous terms and conditions, waive cost of supervision, $100 cost of prosecution, $100 PD fee, and the 24 CF 2626, 11 months, 29 days, Okaloosa County Jail. Credit for time served, $515 court cost, $100 cost of prosecution, $100 PD fee, and the $50 application fee. I think I said it, but it's adjudication of guilt. Anything that I've missed? All right, and again, it's a downward departure, as the state has previously stated, due to the fact that he's previously served the 11 months, or 11, no, not 11, 122.325 months, which I guess is about 11. This was the agreement of the state and uncoerced plea bargain. All right, Mr. Bradley, I need you to be fingerprinted. I think probation still needs to see you because you're just doing county jail and not prison time. So they're going to talk to you after you've been, do you want him to be probation first? Probation first, then fingerprinted, then you have 30 days to appeal the judgment and sentence of the court.
Your Honor, if I may,
Sure.
separate, moving on to the next one.
Okay.
And I apologize, I know you have a lot going on. I think we have a Miss Handy here that we need to serve a subpoena on from an out-of-state.
Oh, is this the Georgia thing?
Yes.
Was it Georgia? Okay, I think it's sitting on my desk, but we've been here since 9 a.m., so.
I've got all the paperwork here, Your Honor.
Okay,
I don't know if, I just wanted to bring it to your attention.
sure. And ma'am, if you could come on up.
Handy.
I know it came in sometime late last week while I was out of town. You can step to the podium, ma'am. Do you have the paperwork?
Yes, Your Honor.
Ms. Handy, you live here locally?
Yes, sir.
Okay, and I guess Georgia wants you to come up to a trial or something to that effect? In state of Georgia versus Brian McManus? Has he lived down here before? Okay, but just the name sounds familiar, so I always got to double check those things. All right, do you have any concerns with accepting the subpoena that you're here? This is how it works. It doesn't happen very often. I think this is the maybe second one I've dealt with in the past 6 months. But if you need to be subpoenaed, Georgia doesn't have jurisdiction over you, so they got to get us to do it.
Okay.
So that's
They
why.
subpoenaed me last week via email.
Well, it's not really effective until this happens. So what date are you supposed to be up there? July 7th through 18th? Well, I would contact whoever's giving this to you and make sure that they give you the exact dates if need be. I'm not sure. Where is Houston County, Georgia?
South of Atlanta.
South of Atlanta? Okay. You have what I need? Servant of honor? There's usually an order for me as well. All right, so. See if you can get, if we get one of our court deputies to serve this on her, and there's a place, I guess we'll cross off the Houston County, Georgia, and put in Okaloosa County, Florida, but this is their form that they use. And I would point out, ma'am, there's a phone number up at the top that says upon receipt of the subpoena, please call. It's probably a witness coordinator or something like that. So that may be the person who can give you better information on when you actually need to be there.
All right.
So.
I think I gave you everything that I have there,
Okay, so, but I'm going to approve the subpoena. I just need one of our deputies to serve it and do that. Since we've got 3 people, I think we can handle it, and then you're going to be free to go. Just make sure, again, you contact them so you understand the whole point of getting your local court to do this is if you don't show up, it's potentially contempt through this court. So, it's one of those things I have to tell people all those things just so they know, because sometimes people don't do it. So, there ought to be a better process, but I guess it would probably take federal legislation to do that. Especially if someone's willing to accept it and not have to spend a day in court. I'm not sure how long you've been here, but probably too long. Okay, not terribly. In the grand scheme of things, that's actually a pretty quick one. All right, but thank you, ma'am. I appreciate you being here. And they're going to serve the paperwork, so just wait for that, and then just take your seat, and they'll get it to you in just a second. Shouldn't be much longer. Thank you again.
Judge,
Got
this is,
something out of Mr. Bradshaw. Go ahead.
this is Roger Bradshaw, 2025 CT 360. It was set plea or continuance. I filed a motion, this is the fellow that I filed a motion for bond.
I'm sorry, is this Roger Bradshaw then?
That's correct, Judge.
Okay.
Roger William Bradshaw.
I received this morning, it was checked into the clerk's office. It looks like a handwritten motion from Mr. Bradshaw, which is listed as a defendant's motion to dismiss for lack of specificity, but lists Federal Rule of Criminal Procedure 12.
Yes, sir. I've already responded to that with a letter. He won't have received it yet, but I saw that this morning as well. I've previously explained to Mr. Bradshaw any motions he files are a nullity. I explained in the letter that also we're in state court, not federal court.
And I haven't read the motion yet, but it came in today, and I saw the name pop up in my email, so that's why I wanted to bring it up. But I haven't had a chance to read it yet, Mr. Bradshaw.
Can I say something, please? sir?
Just 1 second, let me finish it. As your attorney said, if you file something while represented, it's a nullity unless he accepts it and adopts your motion. However, attorneys can only adopt motions for things that they find there's good faith to pursue. Obviously, you're using a federal rule of procedure here. I mean, federal case law and constitutional issues are things that affect state court too, but their rules of procedure are a little different than ours. So there may be some sort of state rule issue. I'm not even sure what this is yet. Again, I haven't read it, but just so you understand, rules of procedure, we use the state rules.
All right.
All right, Mr. Williams.
So at any rate, Judge, this was set plea or continuance.
Okay.
I have filed the bond motion he requested. It's currently set for a hearing on 7/31, and I'm going to have to continue the case.
All right, you wanted to say something, Mr. Bradshaw?
Yes, sir. I've been on, I tried to take care of this case based on hearsay since 2023. And I keep getting run around by Bay County and Okaloosa County when I was trying to take care of this case since 2023. Now, while I was incarcerated at ACI, I tried twice to do it there in 2024. And my response I got back from the clerk, circuit clerk from here and Okaloosa County was they couldn't find my name or case number in the system. I got proof of that in my property. I'm just trying to say that this case has been going for, to me, it's over 2 years. I've been trying to take care of it, but it's just from 23. I just keep getting dragged around, I'd like to get a bond reduction if I can, or ROR.
That motion is set for July 31st.
There's the speedy issue was the issue that I was referring to before at docket day, where I said I didn't want to go ahead and continue it just yet because I wanted to check into something. I did check into it. He was notified of the detainer, but the warrant was not actually served.
And I've seen that done the opposite way before. In fact, that happened in a death penalty case I handled as an attorney 15 plus years ago. So, I mean, it's certainly worth looking into, but I don't know if it did or didn't, Mr. Bradshaw, but
Right.
it sounds like your attorney has looked in that particular issue and found that you hadn't been served with the actual warrant. It was just the detainer portion. I'll be honest with you. There was a bill in front of the state legislature this year that would have helped with your type of situation, where it allow for people who are serving incarcerative sentences to try to resolve their warrants and get them going while they're doing their prison sentence. Unfortunately for you and people in your position, it didn't even get through a committee, is my understanding, so it didn't get anywhere near a vote. But this is a circumstance that happens all the time. I think I tried to handle one or two of these when I was in practice. They are not easy. It involves getting the warden of where you're at involved, usually trying to figure out some sort of resolution. It can be done most easily if it's something that's related to other cases that you're already serving your prison sentence for. But again, procedural rules are what they are. So just like I make sure everyone follows the rules, I've got to follow the rules too. So it's an unfortunate situation that it waits for you until you get out. It's unfortunate for your side of it, at least, and we'll deal with it as quickly as we can. But it sounds like your attorney might need some more time to work on the case, and we'll have that bond hearing on July 31st.
Thank you, Judge.
Okay, anything else, Mr. Bradshaw?
No, sir, thank you.
I can't advise you on how to do things, but I'd just like to give information when I can, when I feel it's the right thing to do.
This doesn't seem, you know what I mean? I'm trying to,
Oh, I understand, Mr. Bradshaw.
I don't understand it at all, so
Well, I don't think I've got the time to go any, I kind of gave you the short version. The longer version is a much longer version.
Right.
But again, I can't really advise you of things. I'm just trying to explain how that works and why, even when you're trying to take care of your case, you sometimes are pushing a boulder up a hill.
Right.
8:27, Judge?
8:27 at 9 o'clock for purposes of the pretrial.
All right, Mr. Bradshaw, thank you.
7:31, you said was?
Is the bond hearing. 9 o'clock.
All right. Who do we have?
No, if, I tell you what, you tell me
That's
who
your
you want
last
me
one.
to subpoena.
Other than-
I'll subpoena them.
The boss. You said you was
The boss, yes. I already have him marked for a subpoena.
Yes.
Yeah.
We
Yeah,
can't
that's
really
De La
talk
Rosa.
about this here, okay, but that's already taken care of.
Who's handling De La Rosa?
Your Honor.
This is State of Florida versus Andrew De La Rosa, 24 CF 1700.
Yes, Your Honor. Last time we were here before the court, Mr. De La Rosa had indicated he was looking into hiring private counsel. He's best suited to say exactly where he's at with respect to that, Your Honor, but currently he has not been able to retain private counsel at this time. If the court has any further questions for him, I welcome his answer.
All right, Mr. De La Rosa, any change in the circumstances?
I'm still waiting on call back and no changes at this time.
And that's why we put it today, because you kind of indicated you thought you were going to have that phone call, I think, the same day that we were in court.
I thought we were.
Okay. Because my concern, and I think I expressed this last time, is you had private counsel who's withdrawn. I've appointed you a public defender, so you had a lawyer because you didn't have one. You're obviously in a situation, at least, like, maybe I shouldn't say obviously, but you've been incarcerated in this case since last July, right? I just want to make sure you had representation, but if you're going to hire someone, it needs to be done. Otherwise, the public defender's office has to do the work on the case, and then if you bring in somebody later, they may say, well, we want to redo a lot of those things. And that's a special circumstance, which I'll allow for that. It's, normally you're not allowed to, say, for example, redo depositions that have been taken. So you've got to get moving on it, otherwise Mr. Maddox has to get going on it. So if there's not any movement on that in the next 2 or 3 weeks, I would say Mr. Maddox is going to have to start setting those depositions, getting ready to get ready for trial, because his case is almost a year old already. Go ahead, Mr.
Your
Maddox.
Honor, I would suggest putting him on the July 10th docket. He has indicated that he's reached out to 2 or 3 firms now, so he was making an effort, and as far as I could tell, that effort seemed genuine. When he was talking to me, it's just about whether someone's willing to take his case or not, and as soon as he gets that confirmation, then he'll either stick with me or he'll go with them, depending on what they work out. But he does seem interested in working forward on his case, Your Honor. And like you said, I mean, it needs to be worked on, so I'm happy to do it. I would suggest the July 10th date or the July 11th date, whichever the court would prefer, see where he's at, and then obviously at that point, we are where we are, and if no further progress has been made, I'll start working on it, Your Honor.
All right. Mr. De La Rosa, sound good?
Yeah.
Let's just put it on the July 11th date. That's that's next Friday. It's our jury review docket, but it's going to be just for status as to your private counsel. And what I'm going to tell you, I mean, I hate to make it sound like what it may be taken as, but either you got to have your private attorney or the PD is going to start doing all the things on your case, because, again, I'm not going to let it linger around.
I understand your
It's one thing when someone gets appointed to represent someone in an old case. It's another when someone gets privately retained. The person who gets privately retained really takes it where it's at and needs to move it quickly. Because they're making that choice to get in when they get in. All right. So it'll be July 11th at 9 o'clock for status on private counsel.
Thank you, Your Honor.
All right, thank you.
I will. Okay.
All right, 25 CF 152.
Correct, Your Honor. It's my understanding that Mr. Reeves was potentially inclined to plea, but I'm not sure the state hasn't offered this time due to them having to go, due to them having to look into it more, as I believe the situation.
Yeah, I have not been able to talk to Ashley about it yet.
So if we could, Your Honor, I hate to keep putting cases, just moving them a couple weeks, but I do think it's another one that potentially could resolve, Your Honor. So if we could put it on the 11th or the 10th.
I would rather just keep them on to the same kind of trial calendar dates. So
Okay,
let's put it on the 11th.
We'll put them on the, I'm sorry, you said the 11th was fine?
Yes, that would be the Friday.
Okay, yeah, that's fine, we'll do that.
Yeah, I'm not trying to put a bunch of things on the 10th where people weren't really expecting to be in court that day.
Sure, understood.
All right. So Mr. Reeves will be July 11th at 9 o'clock, but it's not on the trial docket. It's just for a possible plea.
Thank you.
Thank you.
Afternoon, Judge. This is Merton Brawley. Case number is 2024 CS 1659. Judge, it was set plea or continuance. I was hoping we would be able to get it resolved this time. Back to the drawing board in terms of trying to.
Do you know what else might need to be done? The case is almost a year old.
Let me look real quick, Judge.
I would just like there to be a little bit of a game plan between now and late August.
Judge, I don't know that officers are going to be necessary. The body cams are pretty well tell the story, and we're talking about really. But I'll take a fresh look at it, and if I am going to need to.
All right, August 27th, and that's going to be 9 o'clock for pretrial.
Judge, we've been back and forth several times on offers on this case. We don't have trial.
The study's ready on this, Your Honor.
Ben's ready? Yes, sir. All right, how many days do you think it'll be, Ms. Leone?
One full day of trial for sure. It's pretty straightforward, then jury selection. And most,
Concur, Judge.
very, 2 days. I may have a couple of expert doctors to introduce the medical records of the victim being shot, but I mean, still, I don't think it's going to take long.
As long as they've been listed as witnesses and as experts.
Yeah.
All right.
Yes.
We'll see you on July 11th at 9 a.m. for purposes of jury review and see if we can't come up with that exact calendar, because obviously at this point, it looks like I'm going to have to bring in some reinforcements for this trial period.
Thank you, Judge.
Yeah, you know, Mike, because, are we even setting that for the first or second? I mean, I can only do it the first week, and I can mention to the court, Ms. Sandler just sent an email to the court and Ms. Guzman and us.
I saw it, but I haven't read it.
Right. She said that her medical examiner is only available from the 18th through the 21st, which would be the first week. We don't have trial.
The 18th to the 21st of July?
16th through, I'm
Okay.
sorry, I meant,
I was like, that's a Friday through a Monday.
no, I meant
She's
the
only
last 3
available on the
days.
weekend. I got it.
18th through 21st, okay.
So 16th through
16th
18th?
through 18th.
Okay, which I think we had talked about that case being in the first week anyway, but that doesn't mean that we can't get a backup judge to handle one of them, because I would expect frankly that, well, Mr.
I
Williams.
can't be in two places at one time.
That's, well, that dawned on me as soon as I looked at your face, Mr. Williams. Your
Yeah.
face said it all, so.
And I am not here the second
Believe me, I
week.
wish I could. Judge, well, I'm going to suggest we just leave it on for the 11th. I think this case can be tried in a day. I don't think we can do a pick and go on it and finish in a day.
Well, why don't we, since at least some of us are going to be here on the 3rd, we can always kind of
And I'll be here on
mess around with the calendar, see, and I'm going to see what I can get as far as backup coverage for those 2 weeks in the meantime. Now that I know that we actually going to have more than one trial go, I'll see if I can get that figured out before Thursday, and we'll have, again, I haven't read Ms. Sandler's email. I saw that it came in, but I haven't had a chance to read it yet.
But we're still going to have an issue of Mr. Williams, because the 2 cases that I'm really pushing to try are with Mr. Williams. So we may get another judge, but not another defense attorney.
We'll
Well, I think the issue is, I mean, I kind of have to keep them both set, because I don't want to be in a situation where, for example, I continue Mr. Brown's case and then something happens in the Norris case, which is the other Mr. Williams case for that first week with Ms. Sandler, and then that one goes away. Now I've continued both of them and I can't go forward. I understand that doesn't make it easier on the state to potentially prepare for 2 different trials that you might not be going forward on, but this case is from September of '23. And so if we can get it tried, we'll have to get it tried. But until I know for sure that Mr. Williams' other case isn't going, I can't just say, let's skip this one, because that's what happens. This is why we go from 24 cases set at docket day to 1 trial. Or I think the time before that, it was 17 cases and 0 trials, because these things have a way of either falling apart or getting resolved between now and jury review. So, I mean, I'll reconsider it once we know for sure, but I don't want to be in a situation where I end up trying neither of these cases. All right, so we'll keep it set. All right, thank you, Mr. Brown. We'll see you on the 11th.
Sir, here you go, Mr. Thank you.
Thank you.
Morning, Judge.
Is it
Judge,
still
I don't
morning?
think we're going to be able to resolve this one without a trial either.
Okay.
Back and forth on it. Counteroffers rejected. This is another one.
That's true, Your Honor. The deal with this case is that my victim lives out of state, so we need to arrange travel for her.
I guess maybe we're all going to have to sit down and talk about how we can work these things out where Mr. Williams has numerous, or the PD has several cases that they can only do 1 week, and the state has several cases they can only do in that same week, and they just don't really work out together.
But Judge, from my point, I'm available both weeks on whatever case. My schedule's not an issue this time.
I mean, I'll keep it set and see what I'll end up washing out, or maybe there's someone else from the state that can handle one of the cases that you've got, Miss Leone. I'm going to do my best, but I'm trying to get these cases resolved. I mean, Mr.
Yes, Your Honor.
Durham's case is,
Mr. Brown and Mr. Durham's cases are both old.
yeah, Mr. Durham is from March of 23, so we're past 2 years. I know these are serious cases, but you know, they need to be set eventually. So we'll readdress it on the 11th.
Yes, sir.
But if y'all work something out, or you decide to continue a case because of the circumstances that's starting to build now, I'll certainly entertain that before the 11th and try to clear the deck for everybody. But I just don't want to be in a situation where I keep passing them and then they all go away and we got nothing resolved.
Yes, sir.
So.
It's just, yes, in both cases, though, all the delay has been due to the defense and not to the state. So I understand they're old.
I understand, and I'll consider which ones I'm going to potentially move, but I don't want to move all of them because then we end up with none of them when the last one goes away.
That's fine.
Because if I plan that only Mr. Norris's case with Mr. Williams is going to go, and then I move everything else, and then something happens with that case, then now I've let everybody off the hook with subpoenas and things like that, but.
And that case has a lot more moving parts than any of these others.
And is a lot older than any of these as well. So, I mean, I'm going to focus on that one, but until I know for sure,
Yes, Your Honor, thank you.
they're just all going to have to be ready. All right, Mr. Durham, we'll see you back on July 11th for jury review. Again, for anything as far as motions, let's make sure those are getting filed and set for hearing in advance.
I don't anticipate anything other than the standard limine motion. Judge, this is Mr. Hagan's. The court will recall the last time we were in court, there was some discussion about trying to coordinate this case with a warrant he's got over in Santa Rosa. I don't know if the court got a chance to talk to.
I did.
Try to smooth that over.
I emailed back and forth with Judge Drake Friday. What the plan is, if we resolve his cases and he's ready to be done here, that Judge Drake will issue an order in the case that's in a capia status over in front of him to have him transported to Santa Rosa County, so that way he can resolve that case, but also be served the warrant on the new one instead of getting potentially shipped to DOC and have a problem like we just had with Mr. Bradshaw.
Yes, sir.
But once we finish here today, if that's what's needed, I'll just reach out to Judge Drake and he'll issue that order to have him transported over.
Mr. Higgins, what do you want to do, sir?
Oh, sign it.
Okay. Let me get your signature right there. I'm going to need a clean copy.
Now, Mr. Higgins, understand, I don't know what's going to happen with your cases over there,
I
but I can get you there.
I did some things, so I ain't no issue. But all I wanted to make sure is like I get credit for all my time served, right?
Well, I mean, I can only tell you can get credit for what you did here in my cases, and I can't tell you what's going to happen over there.
Oh, I understand that, but on this case right here, I did sit 9 months in Santa Rosa. That's why I was just saying, like, do I get credit for all my time served?
I don't know if you had a hold from here or not.
I did.
Mr. Williams, have you looked into that? Because,
Yeah,
I mean,
mine-
if you take a look at the part of the plea agreement that you've already gone over, it talks about how the court nor the attorneys can give you any indication as to the exact time you might serve. You know, now, if there's an issue where you think once the jail does the calculation for you, and if you feel they haven't given you credit for what you're supposed to, you can do what's called the 3800B. 3800, I'm not sure if it's A or B, I think
I'm
it's
not
B.
sure if it's- I'm thinking it's B.
It's been too long of a day for me to remember. But it's a 3800 motion where you can say, Judge, correct my sentence because I didn't get credit I should have got. And then we'll bring you back and say, okay, you know what, now we've looked at it based on what the jail has given us, and we'll,
No problem.
you know what, Mr. Higgins, you saw what I've coordinated with another
Yes, sir.
judge in another county to make sure your case is getting resolved the right way. I'm gonna fix anything on the back end too if it needs to be after the fact.
Yes, sir. Yes, sir.
People are entitled to what they're entitled.
There you go.
All right. So,
You mind if I date this for you, sir?
Yes, sir.
so this is Mr. Higgins. You've got 23 CF 2295, where you're currently charged with possession of a weapon or ammunition by a convicted felon, armed trespassing and loitering or prowling, and then you've got 24 CF 2607 with 2 counts of possession of controlled substance. Do you understand that?
Yes, sir.
I've been just handed a plea and sentencing agreement in those cases that would call for you to plea as charged, with the one kind of caveat that in the concealed firearm by a convicted felon case, it's constructive possession, not actual possession, so there's not a minimum mandatory.
Actually, Judge, he had an option between 2 different sentences. He elected the 36 with the
Okay.
minimum end,
That's
so that's no longer an issue.
That's what I'm looking at here, is 36 months anyway.
Yes, sir.
Just, there's a difference between a minimum mandatory and cases, there's certain charges where you can't get gain time. So minimum mandatory just means I have to give you the 36 months, which is what you're pleading to. So I think the first thing I said is not really relevant according to your selection of the 2 offers. All right, so it's the carrying concealed, armed trespass, and loitering and prowling. What about the other case? 24 CF 2607, 2 counts of possession. It's not on here.
Judge, this is the 3rd or 4th time that I have redrafted that plea offer. That's going to time served on the misdemeanors, and the same thing without the mandatory minimum on the
We don't have an agreement that has that one on there.
Judge, give me 5 minutes and I'll write it on there.
Okay. I mean, I could do it, but I think it's just better that y'all get that done, and I'll hand it back. So, Mr. Higgins, what we'll do, we'll call you back up. He's got other cases he's going to take care of. He's going to finish filling that out because the other case isn't on there. And so we'll have you head back, and we'll take care of some more cases and bring you back out today. All right, this is Harrison.
Judge, this is Mr. Harrison. I thought that I had this resolved.
It's 24 CF 2402.
Signed a plea agreement for it, but apparently when I drafted that up, I got him confused with somebody else. The state's not in agreement with that unless they talk with their victim. We're going to have to pass Mr. Harrison, give them a chance to do that, maybe to have to go back to the
That would be fine.
All right, August 27th, Mr. Harrison at 9 a.m. for your next pretrial conference.
Harrison, I suspect we'll get it resolved sooner than that and bring you in. Okay?
Certainly bring it into an earlier date if you get it resolved.
Yes, sir.
Thank you.
Judge, this is Ms. Havens after conversations with the state.
Yes, Your Honor, the state is going to null pros this case based off of the inability to get with the victim, but the last time that we did have contact, the victim did request to dismiss the charges.
Okay. State's announced they're dismissing the case. Is there anything else holding you, Ms. Havens?
I have a VOP in Alabama.
Okay, so they got a hold on you? Where in Alabama?
Anniston, Alabama, 4 hours away.
4 hours away, so it might be a couple of days before they come get you,
They'll be
maybe
here.
more.
They'll be right along.
Okay.
Yes.
Good luck to you.
Only 3 months to get there. It's the longest bus ride I've ever waited for.
I've heard about bus rides a lot longer than that, unfortunately, but. Okay. I once had a client who was on a bus for over 2 weeks.
Your Honor, I'm actually headed that way.
Don't.
No. All right, is this Mr. Horn?
Judge, with regard to Mr. Horn, I've got a bond hearing scheduled for him also on 7/31. State about it. We're just, we're finding a copy of the search warrant for us so I can show that to Mr. Horn. We're just actually.
What search warrant?
For a cell phone
Cell
download.
phone download, okay. All right. Are we getting close to bringing this in for a landing at some point?
I thought I made a reasonable offer.
It's 2 different trafficking charges, right?
The offer was to try,
Just one?
lead just to
I
one.
remember that from last time.
Yes, sir, and stipulate that it was dispositive and so that he could reserve his right to appeal, clock issue.
Just the flock issue was a suppression motion that y'all had followed regarding the traffic stop.
Yes, sir.
All right, so what are you asking for today?
For continuous, Judge.
All right, Mr. Horn, do you understand that?
Yes, sir.
Anything else you want to say about it?
Pardon me?
Anything else you want to say about that?
No.
All right, then I'll put you on August 27th at 9 o'clock for your next pretrial conference.
August 27th. The bond hearing's on 7/31.
Okay. All right, thank you, Mr. Horn.
Judge, just a moment. Mr. Matthews.
Misdemeanors, right?
Yes. All right, Mr. Matthews. Here, this is what I talked with you about. Mind if I date it for you, sir? Do you mind if I date it for you? Do you mind if I put the date down for you?
No problem.
Okay.
All right, Mr. Matthews, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Sir.
All right, can you state your full name and date of birth, please?
Rowan Matthews, 10th of the 9th, 2002.
Okay, Mr. Matthews, you're here in 25 CF 678, where you're charged with aggravated assault by threat, which is a third-degree felony, punished by up to 5 years in state prison, and domestic violence battery is a first-degree misdemeanor, punished by up to a year in county jail. Do you understand that?
Yes, sir.
I've been handed a plea and sentencing agreement that calls for you to plead to a lesser included offense on count 1 of just simple assault, which is a second-degree misdemeanor. punished by up to 60 days in jail or 6 months probation, and then plea as charged to count 2, first-degree misdemeanor. Calls for, on count 1, 6 months of probation on the lesser included, count 2, 1 year probation concurrent, I guess it's really 11 months, 29 days probation. Comply with the ECLC program or to do a substance abuse evaluation, any recommended treatment. Batterers Intervention Program, which is a 26 or 28 week, 26? Okay. I think it used to be 28, that's why I always ask that.
If there's, the first week is
Orientation, okay.
Second week, or evaluation, second week's orientation, so it winds up being
In 28 weeks, okay. Just because when people only have 6 months, I like to make sure we talk about that it needs to be done pretty much on the spot. No contact with Jamila Livingston except as ordered through dependency court, DCF, or ordered in a family law court, because y'all have a child together, Mr. Livingston, or Mr. Matthews.
Yes, sir.
Have you been adjudicated the father in that case yet?
There's not been.
Not yet.
There's no paternity at all, okay. You know, even a DCF case?
That I'm not sure about, Judge.
All right, and you'd be adjudicated on both of those counts. Do you understand that, Mr. Matthews?
Yes, sir.
All right. Have you gone over this, and is that the state's agreement?
It is, Your Honor.
All right, and do you, have you gone over this plea and sentencing agreement with your lawyer?
Yes, sir.
Did you understand it?
Yes, sir.
And did you sign it?
Yes, sir.
Are you satisfied with your attorney's advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir. No.
Okay. Ever hear of anyone smuggling contraband into the jail?
No.
So I ask that question of everybody, even if they've been in prison for 10 years, I still have to ask them those things. You could be under the influence of prescription medications that the
I
jail
don't
gives you.
partake, sir.
Okay. And also, are you are you suffering from any mental health issues or concerns?
No, sir.
All right. Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea?
No.
Do you understand that by entering a plea, there won't be a trial of any kind?
Sir.
Do you understand that you're giving up your trial rights that are listed on page 1, going on to page 2 of the agreement that you signed?
Yes, sir.
Do you understand you're waiving any potential defenses that you may have?
Yes, sir.
And you understand that if you're not a U.S. citizen, this could lead to your deportation?
Yes, sir.
Okay. All right, and what is your plea to the lesser included offense of simple assault and domestic violence battery?
No contest.
All right, I'll accept your no contest plea as freely, voluntarily, knowingly given. Count 1, adjudication guilty, 6 months probation on the lesser included assault. Count 2, adjudication 11 months, 29 days probation concurrent. Comply with either the ECLC program or substance abuse evaluation. Any recommended treatment, batterers intervention program, no contact with Jamila Livingston, except as ordered through dependency court, DCF, or ordered as part of a family court case regarding a possible child in common. Waive cost of supervision, court costs would be, I'm going to have the 151 and 201, 622. All right, $622 court costs. I don't see anything else, so I'll need your fingerprints, Mr. Matthews. I need you to talk to probation first, and then you'll have 30 days to appeal the judgment and sentence of the court.
Yes, sir.
If it's misdemeanors, there's no guidelines.
Judge, this is Akeem Moore. I'll give you the case number. 24 CF 2046. Judge, Mr. Moore had tendered an offer for credit. The state's rejected that offer.
All right, so
He kind of looks older than it was. He was
all right, state, any issues with that? All right, August 27th at 9 o'clock, Mr. Moore will be your next pretrial conference date.
I'll come out and see you again. Yeah. I'm ready for Mr. Moss. And I'm also ready on A. Sure.
Do they have the other name for Moss?
They may have him under Howard. Which we're going to be.
Oh, is that Mr. Maddox's case?
Yes, Your Honor.
Couldn't find her. All right, Ms. Carpenter's here in 25 CF 727, charged with possession of a controlled substance and paraphernalia.
I printed out a copy of the bond motion, Your Honor. Just give me a second to pull that up. Okay. Apologies for that. All right, so Your Honor, this is Ms. Carpenter before the court in 25 CF 727. We're here on a bond motion, at least initially. Is the court ready for that? Essentially, I just rely mostly on the motion, Your Honor.
Well, when was the motion filed?
Motion was filed on June 25th. I believe I provided your office a copy via email. Let me double check, Your Honor.
Yep. I've got some correspondence that was sent by Ms. Carpenter. It looks like it was received on the 19th.
I believe we had also scheduled this at her last pretrial conference just to throw it on the docket.
Well, what I'm saying is, I don't have a problem with hearing it if no one else has an objection. I just don't have the motion that you're relying on.
I don't think I got a copy of it either, but again, I'm fine with arguing because
I found it.
Okay. Yeah, it says bond hearing June 30th, back on the 24th, so, but I just don't have the motion.
Yes. There's one. See if I can find my other two here.
Oh, sorry.
Apologies for this delay, Your Honor.
No, it's fine.
Sincerely.
All right, so you're asking for a $2,000 signature bond.
Yes, Your Honor.
I just checked with my office. We had not received a copy of the motion, but I've read it now.
Okay.
Sure. there a motion for bond reduction, which was filed on June 25th, 2025? All right, Mr. Maddox.
Yes, Your Honor. Okay. So, Your Honor, she's been incarcerated since April 8th of 2025. The present bail of $2,000 cash professional, she's represented to me that she cannot post. She doesn't have the funds to post it. She doesn't have any family members to post it. She just simply doesn't have the money. And although she does have a residence, it's more of a property that she's just been given permission to stay on. She doesn't really have any assets or anything that would be of any help in posting the bond, Your Honor. She has lived in Crestview her whole life and presently intends to reside in Crestview. She's going to be living at a trailer, I believe it was on your grandparents' property, correct? On her grandparents' property, Your Honor, that she has a right to be on. She also has ongoing health issues in the jail, which I'll let her speak about directly. But that's the circumstances, Your Honor, and based on all those things, I would ask the court to consider imposing a $2,000 signature bond, and if we could just put her under oath to ask her about the health issues, Your Honor.
Ms. Carpenter, raise your right hand. Do you swear or affirm that testimony you're about to give us the truth, the whole truth, and nothing but the truth?
Yes, sir.
Go ahead with any questions you have.
Yes, Your Honor. Ms. Carpenter, what are your ongoing health issues currently in the jail?
I have a broken ankle, which I have to go back and have surgery, I reckon. I got the boot for 2 more months. I have 2 aneurysms out of 10. I got 2 more left. I had 2 surgeries. I had them in February.
You have 2 surgeries left?
I got 2 more aneurysms out of 10.
What does that mean?
I got
2 more out of 10, what does that mean?
I had 10 aneurysms in February of last year. Somebody crushed my skull up at Ronnie's car wash. But it left me with 10 aneurysms, and they done the surgery. Then they took me to Sacred Heart and done 2 more, another surgery. And I got 2 more aneurysms right here on each side of my head. And I got heart problems.
Anything else, Mr. Maddox?
No. And do you have anything else, Ms. Carpenter? Do you have anything else? No, Your Honor, nothing further. I would just add that we certainly do not object to any pretrial services or even a GPS monitor being attached upon release.
Your Honor, the state would object. We believe that a $2,000 cash or professional is quite reasonable in this case. One, given the fact that for the charge, it is a reasonable cash or professional bond amount. 2, on the record has 9 failures to appear, some from felonies, some from misdemeanors, including when she was picked up on this charge was also a failure to appear, which she was even given a bond for that one. As for the health issues, Your Honor, take it with all due course. It's hearsay based off of the defendant's testimonies, and typically the jail is more than willing to come in here, and if they have someone who they don't feel they're able to take care of, they will come and let us know, and the state would again rehear any issue and make a deal if that should happen, Your Honor. So based on that, we ask that the bond remain the same.
All right, any other argument, Mr. Maddox?
No, Your Honor.
All right, so. All right, so I'm looking at the first appearance paperwork when Ms. Carpenter was arrested in this case. That shows, as just stated by Mr. Sheik from the state, 9 prior failures to appear, 22 misdemeanors and 19 felonies. When she was arrested on this case, she was also arrested on a failure to appear in 25 MM 592. And I know those numbers sound like a lot, but I'm looking just through this short section I can see since 2023. I could go through it all, but I won't. In 23 MM 2678, there was a trespass, withhold, 23 MM 3924, trespass conviction, 23 CF 2847, narcotic equipment conviction, 23 MM4306, trespassing, conviction. 24 CF 524, possession of a weapon or ammunition by a convicted felon, conviction. 24 MM 455, possession of stolen property, which is illegal possession of a shopping or laundry cart. That was a conviction. 24 MM 1142, trespassing, conviction. 24 MM 1632, trespassing, conviction. 24 MM 1886, trespassing, conviction. 24 CF 2045, possession of narcotic equipment, conviction. 25 MM 592, which is the one I mentioned already as far as the failure to appear. She received a conviction for disorderly conduct and for the failure to appear, and that was she just pled to that in May. So it's why she's been in jail. She pled to this failure to appear.
Yes, Your Honor.
And this current case. So this is not a situation where she's got a $50,000 bond. It's $2,000 cash or professional. And I understand that you're indigent, ma'am, but it seems based on what I just went through, you have a case about every couple of months for the past 2 years. So, the community is not going to be put at risk because you don't want to follow the law when you're out. Now, I'm not making any comment on the current case that you have where you're charged with possession of a controlled substance and paraphernalia, but if someone's being convicted of a new crime every couple of months, in fact, there's a new part of the law that if you have so many arrests, not even convictions, within a 6-month period, that the state can seek pretrial detention against you. So based on all that, I'm not saying you shouldn't be allowed out, but you can't be allowed out just on a signature bond. You're well past that point with the number of failures to appear. I think you're a flight risk. Not that I think you're trying to escape to another country or something, but you're clearly not coming to court when you're supposed to, and you've been convicted numerous times of crimes in this community. So your motion is denied.
Understood, Your Honor.
All right, thank you, Ms. Carpenter.
Ms. Carpenter.
Do you need a copy of that motion? Eventually. Rocky Carter. I still had Carpenter on my docket, so we're just putting her on the August 27th date? She's already set for that? Okay. This was just for the bond.
Your Honor, Mr. Carter has a standing offer from the state for 10 months. He was still debating whether or not to accept it. Do you want to take the 10 months, Mr. Carter?
Speak.
Is it about me?
Hmm.
Do you want a new attorney? Is that what
Speak to the judge.
I don't.
To the state.
Okay. Your Honor, I'm going to advise, Mr. Carter wants to say something. I'm advising him on the record that he should not speak about the facts of his case, but he did raise some issues with my representation potentially, so if he wants to speak to that, he may.
All right. Go ahead, Mr. Carter. Just don't talk about the facts of your case. Raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right.
It's in reference to the 10 that the state has offered me, sir. I just would like a counter offer of 6 months time served and.
Have you done that? Have you asked your counsel to do that? Have you asked your counsel to do that?
Ms. Leone and I have discussed this case rather extensively. I have made every counter that Mr. Carter has asked me to. The state has, up until this point, rejected any lesser incarceration than 10 months, Your Honor.
The reason for this, Your Honor, is because of my grandma's seizure activity, and I need to see my neurologist really bad. And I've already gave the county jail 16 and the Gulf CI 11, and now this.
16 and 11 what?
Months. I've been locked up 34 months. And I got out for 2 days, and I asked my sister about my wallet, and now I'm here 5 months. And I'm trying to see my doctors.
You're charged with felony battery and assault on a person 65 or older.
My sister, I put my arm around.
No, talk about the facts of your case, Mr. Carter.
I'm sorry.
I'm doing that for your benefit.
I'm
Everything
trying
you
to.
say in this room is recorded. The state attorney who's on your case is standing right there with a pen in hand, ready to write down anything you say that could be incriminating.
Okay. Yes, sir, Your Honor, I apologize. I'm trying to keep myself from having at my age, my neurologist said that I'm in the stroke category with my epilepsy, and they got my medicine so strong that I'm really fearing a stroke. If I have a stroke, I won't be no good to myself or anyone else.
I understand that, Mr. Carter, but I don't have any evidence of that other than you saying so. So if you want to talk to your lawyer and get some actual
I'll speak to
medical.
him right now. He's been great.
Can I finish, Mr. Carter? I haven't interrupted you, have I, sir?
No, sir, you're doing
Okay.
great. I'm apologizing.
All right.
I'm not
You know, I don't want to make this a normal thing that I do, but I'm looking through all of your cases and I see, let's see, battery in 2020, violation of pretrial release in 2020, stalking and 3 counts of violation of pretrial release in 2020. And I'm skipping the ones if it was dismissed. Felony battery and resisting in 2021.
All of these batteries, Your Honor.
22, there was another felony battery, 22, a grand theft and pawn fraud, 23, assault times 2 with intent to commit a felony and resisting, and now this current charge. My suggestion, Mr. Carter, if you've got health problems, stop committing crimes.
Yes, sir, I understand.
I'm not saying anything about your current case that's pending, but I don't have any evidence of your health issues other than what you've told me. And if I allowed everyone to get out of jail just because they say they're not feeling well, then there wouldn't be anyone left at the jail.
No, sir, no,
But
sir.
I have a concern, especially because numerous of the things I just talked about are violent, stalking, violation of court orders of pretrial release.
You're totally right. Yes,
So
sir,
I've got a concern about the danger that you pose to the community if I were to just release you.
You're totally right,
So
sir.
the state's offered 10 months. Your choices are these. You can accept the 10 months. You can set your case for trial, not today because we're not set for trial already, but at the next cycle. Or you can plead straight up to the court and I can give you anything up to, including the maximum, which in this case is what, a 3rd-degree felony and the assault is a 3rd-degree felony as well on a 6th person.
Yeah, first
Or is that a
misdemeanor,
misdemeanor?
interestingly enough.
Assault is misdemeanor.
I know it only goes up 1 typically, but I thought we talked about it before, and it may be a different case where it might be a felony. So you're still looking at potentially 6 years incarceration. Just telling you that if you decided you wanted to plead straight up to the court, that's the maximum. Doesn't mean that's what I would give you. I don't know if there's a score sheet that says there's a lowest permissible sentence, but those are your options at this point. Now, if Mr. Maddox, through your counsel, finds some medical records that show that you've got a serious concern, I think it was said in the last case, I've received correspondence from the jail before for people who are significantly ill and can't be tended to in the jail and the state and the PD and my office is involved in that and they've been released to go to a hospital, things like that. But until I actually get some medical records, it's kind of hard for me to just take your word for it.
Well, yes, sir, you're correct, sir. And I have the medical records, not with me, but in the hospitals and the doctor's office, Dr. Cooper at Sacred Heart, and I've been having epilepsy for 46 years.
I understand that.
And now
Mr.
my
Gordon.
heart is acted up in 201 and 24, so now my heart's messed up. And I'm not going to live more than 30 years more, and I'm just trying to get out of this. And I've been awarded Section 8 housing to live by myself.
Mr. Carter, I think I've made myself clear on where we're at with this. I'm not going to entertain a plea negotiation with you, and we're not here for a bond hearing. So your options are, we can bring your case back for trial. We can, you can take the 10-month offer from the state, or you can enter a plea where I'll make a determination of what your sentence will be at a sentencing hearing in the future, which could be anything from time served to 6 years in jail. And I'm not trying to coerce you into anything. I'm just trying to make sure you understand what your options are.
The minimum, Your Honor, would be 17.5 months.
Okay. So you understand that, Mr. Carter? Based on your sentencing guidelines, your minimum sentence would be, unless you're able to convince me to do a downward departure, under 921.026, that your minimum sentence would be 17 and a half months. So you decide what you might want to do. You don't have to do that today. I'm just trying to make sure you understand what your options are. But, the state's allowed to dig their heels in on a case and say, we're not going any less than this. And I don't know enough about your case or your history other than what I just read to you to make a decision on the fly today. But I've got concerns about, the violent nature over the past 5 years.
Well, I'm afraid to speak of any of the cases
Yeah,
because
no, and please
I'm
don't.
not going to do that.
I told you what you've been
Yes,
convicted
I-
of, so you can say I didn't do it, but you've been convicted by a court that says you did after you entered a plea. So that's your history. All right. Anything else from Mr. Carter today?
No, Your Honor,
No,
we
Your
have
Honor.
depositions scheduled July 8th. Given Mr. Carter doesn't take an offer before then, we'll follow through. on
I'll
that.
certainly take it. If y'all come up to a resolution that you agree upon, I'll entertain it on any day you can get it.
Is the 10-month offer still open or no?
All right, August 27th, 9 o'clock.
Think on it a little bit, Mr. Carter.
Will you come see me and talk to me,
Yeah, sure.
please?
Yeah, I will.
You're all I got, man.
I understand.
I'm sorry if I was rude.
I don't know. I mean, I know
I'm being beat up in the jail.
Mr. Maddox, are you waiting on something from is it Mr. Threet still is waiting? Mr. Threet, I think, is still waiting, or no?
Oh.
Threet?
Yes. No, he's. I'm just going to ask for a continuance in that case,
Okay,
Your Honor.
let's finish up Mr. Carter's case. I think we're done. Mr. Carter, we'll see you back on August 27th.
Thank you.
You're welcome.
And Mr. Threet, if you could come up quickly. Mr. Threet, sorry, I was away from the microphone.
Sorry, Your Honor. This is Mr. Threet. He's back up before the court, Your Honor. I am asking for a continuance in this case.
All right, state have any objection? No objection. All right, August 25th at 1 o'clock from Mr. Threet. We'll see you back on that date. Stay in touch with Mr. Maddox.
Sure.
He was here this morning and couldn't have gone far. Judge, this is Mr. Moss. It's the negotiator. You realize one of those is still up. Get your signature.
Can I see the front page real quick?
About 10.
Oh, no, you got this cool. Change it.
Make sure it's.
Probation.
Well, let's finish this. No, this one. If Joe.
There you go.
All right, I'm reading the report as to Mr. Moss, and I guess it's Jason Howard is actually the alleged victim in this case, is that right?
That's correct, Judge.
Has he been contacted pursuant to Morrissey's law, Mr.? Okay. Anything else I need to know about that?
No, I don't believe so, Your Honor.
Okay, Mr. Moss, raise your right hand. Do you swear or affirm the testimony about to give us the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
State your name and your date of birth.
Joseph Moss, May 1st.
What's your middle name?
Michael,
Joseph Michael Moss, date of birth?
May 1st, 1988.
Okay, and Mr. Moss, you're here in 25 CF 829, charged with illegal use of personal ID, giving false name to law enforcement, causing harm, 3 counts of giving false name to a law enforcement officer, and false official statement. Do you understand those charges?
Yes, Your Honor.
I've been handed a plea and sentencing agreement that would have you plead to counts 1, 5, and 6, with the state dismissing counts 2 through 4. Sentence would be adjudication of guilt, time served, each count concurrent, 515 court costs, $150 PD fee. And Mr. Williams, what are we doing on the money part of it? Judgment?
Just take it to judgment, sir. He's got a capias out of Indiana under the name Howard, and part of the agreement.
Under the name of this particular victim?
Excuse me?
Under the name of this victim?
Yes, sir. And
does he have charges up there for that?
Yes, sir. He's got actually a violation of parole up there. And so part of the agreement is he's going to waive extradition and
All right, so he'll be transported straight to Indiana from here?
Yes, sir.
To face his new charges up there as well as his parole violation?
Well, I don't know that he's got new charges up
No.
there, Judge. I know he's got, what's been represented to me is that it's a parole violation.
Is this the state's agreement? It is, Your Honor. So he's been in jail for about 2+ months here? Yes, sir. After giving a false name repeatedly to avoid probably his parole violation?
I'm very sorry for that, Your Honor.
All right, is this what you want to do today, Mr. Moss?
Yes, Your Honor.
All right. And the state has given me the guidelines that show 26.4 points, so he doesn't score prison. All right. Have you gone over this plea and sentencing agreement with your lawyer, Mr. Moss?
Yes, Your Honor.
And do you understand it?
Yes, Your Honor.
Did you sign it?
Yes, Your Honor.
You satisfied with your lawyer's advice and representation?
Of course, Your Honor.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, Your Honor.
Are you currently suffering from any mental health issues?
No, Your Honor.
All right. Has anyone forced, pressured, or threatened you in order to enter this plea?
No, Your Honor.
Has anyone promised you anything in return for your plea?
No, Your Honor.
And do you understand that there won't be a trial of any kind if you enter this plea?
Yes, Your Honor.
You understand that you're giving up, your trial rights would start on page 2 and continue on, page 1 and continue to page 2 on the agreement that you signed?
Yes, Your Honor.
Do you understand you're waiving any potential defenses you have?
Yes, Your Honor.
And do you understand that this will be 1 felony conviction and then 2 misdemeanors?
Yes, Your Honor.
All right. And do you understand that if you're not a U.S. citizen, this could lead to your deportation?
Yes, Your Honor.
Okay. What is your plea to the illegal use of personal ID information, which is a 3rd-degree felony, 1 count of giving false name to a law enforcement, and 1 count of false official statement?
That's what it is. No.
I plead no contest, Your Honor.
All right. I'm going to accept your no contest plea to counts 1, 5, and 6. State have an announcement on 2 through 4.
State will dismiss those counts, Your Honor.
Okay, adjudication of guilt, time served, concurrent, I'm not sure what's concurrent, 515 court costs, $150 PD fee. Those fees will go straight to judgment. Mr. Moss, you've got to be fingerprinted, and then you have 30 days to appeal the judgment and sentence of the court. So I understand you'll be transported directly to Indiana to face your issues up there.
Thank you, Your Honor.
All right, good luck. Mr. Sheik, do you,
I'd have to look
as
at
far
the
as the
guidelines.
Jason Howard fugitive warrant, are you ready to do something at that point?
I think we probably should wait until it actually officially occurs, Your Honor.
Okay. I'm fine with that. We'll put that on August 27th at 9 o'clock for status. Thank you.
What I just hand wrote it in there. You've got the possession of controlled substance and F3, 5-year maximum, then 2 misdemeanors, possession of paraphernalia and possession of less than. Is that still what you want to do?
Yeah.
Okay.
Thank you. All right, Mr. Higgins, I think we talked a little bit earlier, but raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. State your full name and your date of birth, please.
Riley Tyrell Dale Higgins, 21190.
All right, and Mr. Higgins, you're here in 23 CF 2295, charged with carrying a concealed firearm by a convicted felon, armed trespass, and loitering and prowling. And in 24 CF 2607, you're here on possession of controlled substance, possession of paraphernalia, and possession of less than 20 grams of marijuana. Do you understand all that?
Yes, sir.
All right, I've got that. You're going to plead as charged to all of those counts. With the one caveat, again, as we talked about, is that it'll be constructive possession of the firearm charge in count 1 of 2295. I'm not sure. I think we talked about that. It doesn't really matter at this point because you're taking the 36 months anyway, right? All right. So the plea agreement to those 6 charges will lead to an adjudication of guilt, 36 months DOC. Are we doing just, oh, there it is, time served on all misdemeanors.
Yes.
Thank you, Mr. Williams, you got that there. 515 in court costs. Well, he's got 2 different cases. What would the other court costs be?
Be the
515 on both. 150 PD fee should actually be 250, just because we have to add the second case.
Yes, sir.
250 on the PD fee, and then credit for time served. Do you understand that, Mr. Higgins?
Sir.
All right, so it's 36 months plus 515, 515, and 250 in costs. Is that your understanding?
Yes, sir.
Did you go over this plea agreement with your lawyer, Mr. Williams?
Yes, sir.
Did you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Are you satisfied with your attorney's advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
Do you understand by entering a plea there won't be a trial of any kind?
Yes, sir.
And do you understand that you're giving up your trial rights, which start on page 1 and go on to page 2 of that agreement that you signed?
Yes, sir.
Do you understand you're waiving all potential defenses you may have?
Yes, sir.
And do you understand that if you're not a U.S. citizen, you could be deported because of this?
Yes, sir.
If I didn't say so, you understand this is an adjudication of guilt, so you're going to have 3 different felony convictions from this.
Yes, sir.
Okay. And what is your plea as charged to each of the 6 counts?
No contest.
All right, I'm going to accept your no contest plea as freely, voluntarily, knowingly given. Adjudicate you guilty on all 6 counts. On the misdemeanors, it's going to be time served. On the felonies, it's going to be 36 months Department of Corrections, concurrent and credit for time served. Court costs of $515, and a $250 PD fee, which is $100 per case plus the $50 application. Send those to judgment.
Yes, sir.
Right. All right. Judgment for those. All right, Mr. Higgins, you got to be fingerprinted, then you have 30 days to appeal the judgment and sentence of the court. It's my understanding that despite this being the minimum mandatory sentence, it is still a downward departure.
It is still because it goes below the guidelines, yes, Your Honor.
Okay, it's below guidelines, which are 44 months. And is that because of an uncoerced plea bargain?
It is, Your Honor.
Okay.
It is.
Yes, it's the same. It's just constructive or actual possession is the difference between minimum mandatory, but he's still doing the minimum mandatory anyway. So I think we talked about that earlier. It's somewhat of a moot point.
We
Minimum
have to,
mandatory. It is
yes.
a mandatory. So what I said about it not being a minimum mandatory is again, it's kind of moot at this point, but so it is the minimum mandatory. It's my understanding, and I've had a lot of conversations about this, minimum mandatory doesn't mean day for day, no gain time, unless the statute specifically says it. For example, 794, I think Bat Leo also does day for day, you have to do everything, but there's several statutes that say that, but minimum mandatory is not that. You can still get your 85% on a minimum mandatory.
Yes, sir.
Unless it specifically said no in the statute, but DOC determines that.
Yes, sir.
All right. All right, so Mr. Hagens, I need to be fingerprinted, and then you got 30 days to appeal. As soon as I get a chance right now, I'm going to send that email to Judge Drake about issuing the order to have you transported over to Santa Rosa County so you can take care of your case and your active warrant over there.
Yes, sir.
All right, good luck.
Thank you, Judge.
So this is Frost.
Yes, Your Honor. This is Mr. Terrell Frost. He's before the court in 3 cases. Care if I date it for you? We're going to resolve all of them, Your Honor.
All right, so this is Terrell Frost in 2018-2999. Drive while license suspended, 18 CF 3017, burglary, unoccupied structure, 25 CF 884, possession of a weapon or ammunition by convicted felon, and theft of a firearm.
Yes,
Are
Your
the
Honor.
old cases, are those VOPs?
Yes, Your Honor. The 2
Okay.
of them are VOPs. The new case are new law charges.
All right. You have a plea form?
Yes, Your Honor.
Thank you, sir. All right. So is this going to be a constructive possession issue with the firearm charge?
We agree. Well, I'll let the
State, you
state
agree,
speak to
state,
that,
are you
to be
agreeing
honest.
it's a constructive possession to avoid the minimum mandatory?
Yeah, that's.
Okay. And it's, the guideline sentence was 53.775 months.
Correct, Your Honor.
That's the state's agreement is 3 years probation?
Yes, Your Honor, it is.
Okay. Mr. Frost, you're here on the cases that I mentioned. I've been given a plea and sentencing agreement that would have you plea no contest in the new case, admit your violation of probation in the VOPs to 3 years probation concurrent across all 3 of those cases, revoke and terminate your previous probation terms. Any concern that as to how much probation he's already served in those old cases, just because they're from 2018?
No, it was told shortly after he got on probation, Your Honor. It was told 6 months or so after. Initially, I believe that was a 3-year term that he had done, so no, I don't think so.
Okay, so his probation had been told for the vast majority of the past 7 years?
It started, his sentence was assigned in 2020, Your Honor, I believe. And then a few months after that, he picked up his first violation. I believe that affidavit was either filed in 2020 or 2021. So no concerns there with the 3 years.
Okay, I just want to make sure there's not potentially an illegal sentence if it's more than 5. Sir?
Yeah, he is past term. That's certainly true.
Well, he's past term, but he's been in violation status the entire time. I know we've had this discussion. If he's on probation and he's in a violation status, and I'm ordering that it was told during that time, then all right. Otherwise, people can just violate their probation, not do anything for a few years, and then say, well, you can't get me anymore. You just have to give me time certain. I just.
Might get to make that argument. Not here.
All right, so Mr. Frost, and it also involves a 60-month suspended sentence?
Yes, Your Honor.
I think some of these plea agreements y'all come up with could be a law school exam on what an illegal sentence could be. Let me understand that. So he's alleged to have absconded in June of 2021. He was then picked up in April 30th or so, 2025. So almost 4 years. And the agreement is to put him back on probation.
Yes, Your Honor. That's what my client wanted to take.
When he's got a minimum mandatory firearm charge and he scores 53 months. I mean, if the state's going to negotiate the pleas, that's fine, but ultimately, you're the ones that have to talk about, why you did it at some point. I don't know the facts of the case, but if someone absconds from probation for 4 years, I'm not sure if probation is
I realize that, Your Honor, but then we have a backlog of cases set for trial, and sometimes we had issues with one of the witnesses, I guess, who was occupying the car. Some statements that she made contradicted herself. Cases.
Okay, I understand.
What it is.
And if I may, from my perspective, Your Honor,
I'm not really asking for responses, it's just making sure it's known. And normally what I've been doing is once the negotiated plea is accepted by the court, and if the state wants to put anything on the record as to why they offered it, then you're free to do that. But it's not for me to step into any particular case and say I know it better than the two people who are working the cases and the investigators who were involved. But
And Your Honor is correct in thinking that it's been avoiding supervision for like 4 years, and that's the suspended sentence. And why 60 months? He scores 50 some, I think, minimum. And I figured if he violates, he's going to get at the very least 6 points for technical violation. It would be to 60 months, and that's the very last chance he gets. My position will be that if he violates, I will be asking strictly for the suspended sentence.
Oh, I understand that, but just my issue is suspended sentences are only, kind of worth, whoever's handling them once they come back.
That's true. Yeah.
But as y'all know, suspended sentence is basically it's not a cap in this case because it's the maximum penalty, but oftentimes the suspended sentence is, 36 months. And all that does is limit what the judge can do when it comes back on the violation, but the judge can still do less. So I've never really understand when I was a prosecutor, when I was a defense lawyer, and I was a judge, what the real use of suspended sentences are. But all right, Mr. Frost, is that the 3 years probation, revoke and terminate your current probation, adjudicate you guilty, but complete all original terms of your probation. Court costs, what would the new case be? $515 court costs on the new case, $100 VOP on each of the two VOPs, and then $350 in public defender fees, and there's the 60-month suspended sentence. Is that what you want to do?
Yes, sir.
Is that the state's agreement?
It is.
All right. And Mr. Frost, did you go over this plea and sentencing agreement with your lawyer?
Yes, sir.
Did you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
And are you satisfied with your attorney's advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
You understand that if you enter a plea of no contest in your new case, that there won't be a trial of any kind?
Sir.
And you give up the trial rights, which are on page 2 of the agreement that you signed.
Sir.
And you understand if you admit your violations of probation in the 2018 cases, that there won't be an evidentiary hearing where the state would have to prove how you violated your probation.
Yes, sir.
And do you understand you're waiving your potential defenses that you have in all 3 of these cases?
Yes, sir.
And do you understand if you're not a U.S. citizen, this could lead to your deportation?
Yes, sir.
Do you understand you'll be adjudicated guilty on all counts, all cases?
Yes, sir.
All right. And what is your plea to the new charge, the possession of a firearm by a convicted felon? Again, is that limited to a constructive possession, Ms. Leone?
It's good.
So that way there's no minimum mandatory. And then the grand theft of the firearm, what do you plead to those 2 charges?
Guilty, sir.
No contest.
Oh, no contest. I'm sorry. No contest.
And as far as the violations of probation, are you admitting or denying your violation of probation?
Amen.
All right, I'm accept your no contest plea in 25 CF 884 and your admission to the 2 violations of probation. Adjudicate you guilty, all cases, all counts, 3 years probation, concurrent across all cases, revoke and terminate your previous or current probation that you were on, complete all the original terms you have to complete on the new period of probation. Court costs are going to be $515 on the new case, $100 VOP fee on each of the VOP fees, and a total of $350 on the public defender fees, a 60-month suspended sentence. And this is a downward departure based on uncoerced plea bargain?
Yes, sir.
Mr. Frost, I need you to speak with probation, then you step up and be fingerprinted. You have 30 days to appeal the judgment and sentence of the court.
Yes, sir.
All right. Good luck, Mr. Frost.
It's for all 3. Concurrent for everything.
Of course.
Thank you.
Your Honor, if we could just take a minute here.
Sure. Yes, ma'am. Since he never really served the 3 years of probation initially, because he violated by absconding pretty quickly. 60 months suspended, yes. Which limits his exposure on the possession by a convicted felon. Who do we have, Mr. Mannix?
Your Honor, this is Miss Gloria Green before the court in 25 CF 494, plea or continuance. I have the state's previous offer, and I did talk to Miss Leone about this, but I'm not sure we have any new offer at the moment. That's correct. Okay.
Yeah, it's everything.
Take up the court's time with here.
Okay.
Okay.
Thank you, Ms. Green. We'll bring you back. Who else do you have, Mr. Maddox? Do you know?
I
who's
believe,
coming next?
I don't know who they're calling up here next.
I understand, I observed. All right, Austin Geis, 24 CF 2576 and 25 CF 375. What are we doing with Mr. Geis today?
I believe we have a resolution, Your Honor. Sure. Okay. Is June 30th. 6:30. All right, Your Honor, may I approach?
Sir. All right, Mr. Geis, can you raise your right hand to be sworn? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, Mr. Geis, I'm sorry, can you state your full name and date of birth, please?
Austin Gregory Geis, October 31st, 1996.
All right, Mr. Geis, you're here in 25 CF 375, where you're charged with domestic violence battery by strangulation, third-degree felony, and 24 CF 2576, possession of a controlled substance, third-degree felony, drive while license suspended, first year, it looks like years, first-degree misdemeanor. I've been handed a plea and sentencing agreement that calls for you to plead to a lesser included on the 375 case to misdemeanor domestic violence battery, 11 months, 29 days probation, batter's intervention, no violent contact with the alleged victim. Court costs would be, $622 on a domestic? And $150 cost of defense. That's a lesser included under 784-031A. 24 CF 2576 be as charged. Credit for time served on the count 2, drive on license suspended, but 5 years of probation, substance abuse evaluation, any recommended treatment, and comply with the ECLC program. Court costs on that would be for $515. Why do I always think there's a drug surcharge? Oh. I'm not. I just want to make sure I'm getting the right one. All right. Is that what you want to do today, Mr. Geis?
Yes, sir.
All right. And is this the state's agreement?
It is, Your Honor.
Okay. I'm looking at guidelines that show 50.2 points for a lowest permissible sentence of 16.65. So this would be a downward departure. Is that based on uncoerced plea agreement?
Yes, Your Honor. And I believe also the need for substance
Treatment.
abuse treatment.
Okay. All right. Mr. Geis, did you go over this plea and sentencing agreement with your lawyer?
Yes, sir.
Did you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Are you satisfied with your attorney's advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
You understand if you enter this plea, there won't be a trial of any kind in either of these cases?
Yes, sir.
You understand you're giving up your trial rights, which are on page 2 of the agreement that you signed?
Yes, sir.
All right, and you understand that you're waiving any potential defenses that you may have?
Yes, sir.
And do you understand if you're not a U.S. citizen, this could lead to your deportation?
Yes, sir.
Do you understand that it's an adjudication of guilt, so you'll have a felony conviction on the possession of controlled substance, as well as a felony conviction on the domestic violence battery?
Your Honor, that's a misdemeanor.
But it's a conviction, right?
Oh, yes, I'm sorry.
Okay, and a domestic violence battery will be treated by the federal government as something that says you can never own a firearm again, either way.
Yes, sir.
Just want to make sure, I mean, he's got a felony conviction show,
Yes,
so
sir.
it shouldn't really change anything, but there is an important thing to bring up about
Yes, sir,
domestic
Your Honor,
violence
my
battery
apologies.
charges. It's okay.
Your Honor, if I may speak, if we have a World War III, like, will I be able to have a firearm?
I don't know if I can answer that. As long as the state of Florida's government and the United States government exists, you won't be able to own a firearm unless you go through a process of clemency for purposes of restoring your firearm rights. I can't give you advice on how to go about that, but it's something that can be done with the governor's office.
Yes, sir.
But since you also, from a federal standpoint, would have a domestic violence battery charge, you'd have to get potentially federal clemency as well for that purpose.
Yes,
I
sir.
can't give you any advice. I'm not saying that's exactly what's needed, but that's a concern.
Yes, sir. Thank
Let's just all keep our fingers crossed there's no World War III.
you. Seriously.
All right. What is your plea to those charges, Mr. Geis?
No contest, Your Honor.
All right. I'll accept your no contest plea to the misdemeanor domestic violence battery. Adjudicate you guilty, 11 months, 29 days probation, batter's intervention program, no violent contact with Tiffany Hunter. 622 court costs, 150 cost of defense. Again, that's a lesser included under 784.03, paragraph 1, subparagraph A. 24 CF 2576, count 2 is plea, I accept your plea on the driving license suspended, credit for time served, adjudication. And on the possession of the controlled substance, 5 years probation, substance abuse evaluation, any recommended treatment, or comply with the Emerald Coast Life Center program. And that will be the $515 in court costs. You also have another $150 or $100 PD fee on that case. Just to make sure you understand how this is structured, Mr. Geis. Your batter's intervention program is listed on your battery case. You only have a year of probation on that case. So if you don't finish that 26 to 28 week long course in that first year, you might get violated. So you need to get on that batter's intervention program as soon as you get out.
Yes, sir.
So it's in your best interest to get that done in your first 30 days.
Is there something like in the paperwork to where like I'll be able to know where to go that's going to guide me
Your
to?
probation officers will
Okay,
instruct
yes,
you of
sir.
those things and where you can get that done.
Yes, sir.
But get it done as quickly as you can.
Yes, sir.
All right. And this is a downward departure based on negotiated plea bargain or uncoerced plea bargain. You're going to have to talk to probation, Mr. Geis, then you'll be fingerprinted. You have 30 days to appeal the judgment and sentence of the court.
Thank you, Your Honor. And those, I did put in there their concurrent sentences, correct?
Concurrent probation, yes, sir.
Sir, thank you.
All right, good luck.
Thank you.
Yes, sir. Thank you.
That's this out of order now. All right. Oh, this is Mr. Maddox still.
Your Honor, if I may.
Go ahead.
This is Mr. Jeffrey Moore before the court in 24 CF 1357, 24 CF 1358, and 24 CF 2894. If I may just have a brief moment to speak with the state, Your Honor, Mr. Moore would like me to make one last attempt at counteroffer for him, and today is the last day for him to take a negotiated plea.
Okay.
I don't know that Mr. Sheik will even entertain it, but
Okay.
I'll ask him. I did ask if Mr. Sheik would be interested in taking the offer that Mr. Moore countered with. Mr. Sheik said no.
Okay. All right, so what are we doing with Mr. Moore's cases?
Your Honor, it is set for plea or trial, so I will leave it set for trial. Obviously, we'll
that's-
have to figure out the logistics of that, but
And that's the 24 CF 2894?
Correct,
That-
Your Honor.
yes, Your Honor. And then there is a motion for severance that we do need to address, Your Honor, but I'm not sure if the state will be objecting to that or not.
Actually, I think that will work out, Your Honor, if we do, based off of I spoke with the vet, that's the expert witness in the animal abuse case, Your Honor. Will only be available like one of the days during the 2 trial weeks, and she's in training. So to avoid any conflict, I think if we sever it anyway, as the defense is asking, and then go forward with the possession of controlled substance, that would be the state's opinion on that one, Your Honor.
Are the 224 cases, are those new or VOPs?
Those are VOPs, Your Honor.
Okay.
And if Your Honor is inclined, we could put the VOP at the end after we do the trial, but I know we're very, very busy, so.
All right, so it sounds like the state's not objecting to the motion to sever, but is stating they want to go forward on the possession charge of the severed cases.
So, yes, that is what the state relayed, Your Honor. As I mentioned to the court, I would like to go forward on the aggravated animal cruelty charge, but if the doctor's going to be available.
What's the available date?
I apologize, it's 2 dates, it's the 14th and the 15th, Your Honor.
The 14th is a jury selection date.
Yes.
How many days would you think the trial would last, Mr. Sheik?
I think a trial would, well, if we.
Depends which one it is, I
On
guess.
the aggravated
Yes.
animal cruelty case, I would say,
And the state, regardless of that, would still want to go forward on the possession of controlled substance, Your Honor.
So let me just kind of reset the table here to make sure we understand this. We'd only be going forward on one of those charges from that case because the defendant has asked for it to be severed. So regardless what happens in that trial, the other case is still pending along with the 2 VOPs for which he's got no bond.
Correct.
What would you like to do, Mr. Maddox?
so here's what the situation is, Your Honor.
I think I just explained what the situation
No,
was, Mr.
I'm
Maddox.
sorry. So Mr. Moore, really what he wants to do is go to trial on the animal cruelty case. However, obviously the state's made their concerns aware, and then one of the witnesses that is needed for trial is not going to be available. I severed the cases. He does not. He's indicating to me that he doesn't want to take the controlled substance case to trial. As I've indicated to him, the offer currently, if he wants to take an offer in the case, is 36 months Department of Corrections followed by 2 years of probation, which he's indicated he doesn't want to take. So I've explained to him that we're in a
Say that
position
again.
now.
What was the offer?
36 months Department of Corrections and 2 years of probation to resolve everything together. There's no offer on the table to resolve anything separately or any other
So
circumstance.
let me make sure I understand. Is that just on the possession charge or does that include the VOPs as well?
It's to resolve everything, but I've certainly not
Oh.
been made an offer exclusive to the possession controlled substance charge, and Mr. Sheik has not indicated that he'd be open to doing that.
Okay. All right, Mr. Moore. Mr. Moore.
Your Honor, I understand what, they're trying to offer. Honestly, like me personally, I would really like to try to get this resolved today. Unfortunately, prison is not for me. Okay, I understand like the points that I have against me and stuff like that, but I only have like literally 4 misdemeanors on my record. The only charges that I have that's felony are the ones that I'm facing, and that is it. And if they're offering 36 months followed by 2 years probation, I mean, I would gladly, sign anywhere between 36 months to 60 months suspended sentence with 3 years probation followed by 6 months CC if they're willing to do that to resolve all of this.
Well, I think whatever your counteroffer has been conveyed and rejected.
Correct, Your Honor.
All right, well.
So your choices are these. You can take what offer the state's been given, has given you. You can set your case for trial, which we are, at least on one of them. The VOPs are still out there.
Sure, Honor.
Or 3, you can plead straight up to the court, and then I could sentence you from anything, from the minimum to the maximum, which the animal cruelty, is that a third or a second?
It is a third, I believe.
It's a third. So potentially, you have 10 years of exposure on the new case of DOC, and then you've got 2 more VOPs of third-degree felonies. So you're looking at a potential, I mean, I can give as much as 20 years in state prison for the 3 of these cases. I'm not saying I would, but I don't know what the guidelines would tell me. I don't know what your history is other than what you just said. I'd certainly listen to any mitigating and aggravating factors as to why you should get one sentence or another, but you'd have to enter a plea to get there.
Well, Your Honor, like, I would not mind doing that. However, there's a couple of things that I would like to state to you before I necessarily do that, so that way you can.
Just so you understand, Mr. Moore, I won't give you any indication as to what I would sentence you to if you plead straight up. All right, go ahead. Mr. Maddox, where are we at?
So, Your Honor, he's asking, basically what he's trying to figure out is whether or not he wants to plead straight up to the bench on just the possession of controlled substance charge. As I've told him, he's facing a violation of probation currently, and to plead to that charge without a trial, if he wants to do that, he can, but it's not necessarily the best position for him, and it's certainly going to negatively impact his VOP without exercising his constitutional right to a trial. And he's at the mercy of the court on that. So he has concerns. They're legitimate concerns. I certainly have tried to explain them. But again, I don't I don't want to put the court in its position where we're going back and forth.
I'm not in a situation where I'm going to tell you what I'm going to do either. Like I said, Mr. Moore, so you can either plea or not plea, or we can go to trial or not go to trial. I mean, I'm giving you the options here. Those are what you're entitled to. But I can't tell you what's going to happen based on what you decide. But we're set for trial on a case 24 CF 2894 where you're charged with aggravated animal cruelty in possession of a controlled substance. You've asked to sever that case, so the two charges are treated separately due to the fact that they apparently happened some 8 to 12 hours apart, I think was what the motion said. 15. The state doesn't have an objection to that, but that means we just have to go to trial on one or the other. The one issue from the state side is that their veterinarian expert can only be available on one day of the 2-week trial period. So we'd have to set it up for that purpose. I know I'm already set in a trial for the 15th and 16th with Mr. Cobb, and I'm not sure if that's Ms. Basso or Ms. Barrickman, I think is on that case. I think it's Ms. Basso. So it may be a situation where it's a different judge than me would be handling that particular trial.
Would that be this month?
It would be the same days that we're talking about, the 15th. If the veterinarian is available that day, I'd do my best to get the trial set that day. But what I'm telling you is, if we have to have a fill-in judge, whether that's some current active judge who is free that day who can handle it, or we'll bring in a senior or retired judge to handle one of the trials, there's a good chance it would be yours due to the fact that yours is a one-day trial, and I've already set another 2 to 3 day trial over that same period. And then I definitely can't tell you what the other judge would do, because as you have to understand, if you go to trial with one judge, that judge has to do your sentencing. So it wouldn't be me.
Your Honor, if I may, I don't know if the possession of controlled substances would definitely be a one-day trial. I don't know if the animal abuse one would be.
Okay.
Because we would have an expert witness. We'd also have 3 or 4 witnesses that were there, and then the owners.
What would you like to do, Mr. Moore?
And then, Your Honor, just if I may, just to be clear for Mr. Moore, you will accept a plea to the bench if he does decide to do that at any point after today or no?
After today, the only plea that will be accepted is as charged, guilty as charged.
Pleading guilty straight up to the court. All right, yeah, we'll leave it set for trial, Your Honor. The possession of controlled substance.
On the possession of controlled substance?
I mean,
That would be the state's request, Your Honor, and based on us having the burden of proof, we would ask to go forward on the possession of controlled substances cycle, Your Honor.
Okay.
Said what, the only other day we could do the animal cruelty charge was the 15th.
The 15th. And again, I've got another trial set. I'm not trying to give you any hints or tips as to
No,
what
I
you should
understand.
do, but simply say this might be the circumstance. You may end up with a different judge who not only does the trial, but also sentences you if you're convicted.
I mean, so, I mean, just because that's what my client wants to do, my position is that we should try the aggravated animal cruelty charge first if we can arrange for it to be tried on the 15th, but obviously the court will decide which case we go to trial on, and both sides have made their pitch, so I'll leave it to Your Honor.
Well, based on the limited availability of the state's expert, I would have you go forward on the possession charge.
Okay.
And again, the defense has asked for that severance. It's not like I forced that upon you or the state's asked for it.
No.
So again, as I've stated, even if that's an acquittal, there's still the other case plus the 2 VOPs pending. So that's, motion to sever is granted without objection. And we'll go forward on the possession of a controlled substance, and that's a one-day trial.
Yes, Your Honor.
Anything else?
No, Your Honor.
All right. Thank you, Mr. Moore. We'll see you back on July 11th at 9 a.m. for our jury review docket. Mr. Rivera, we still have other cases. We're on our 9 o'clock docket.
I understand. You understand that I'm a disabled person and I need my medication. I've been here since 1:30 and I need to take my medication for my conditions, which essentially now I'm here and I can't even go take care of my condition. I asked the court to please have consideration when they bring me in to these situations because I also have my conditions that I need to take care of.
Okay. Mr. Rivera, have you brought that to the attention of court administration as far as an 80? Can I finish, Mr. Rivera? You're not going to keep interrupting me like you do every time you're in court.
Go ahead, but I see you're prejudicial towards me.
I'm not being prejudicial. Do you think I'm prejudicial towards you? All right.
I think this gentleman right here.
All right, I'm going to go ahead and recuse myself. Mr. Rivera, I'm going to recuse myself from your case based on your multiple claims that I'm somehow biased against you. I'll sign that order. You'll be reassigned to another division. All right. Thank you. For control, we're going to put you on. Can I finish? I'm going to put you on a control date for August 25th at 1 o'clock. But once you get reassigned to another division, Mr. Rivera, they're going to give you a court date in that division. I don't know if that will be Judge Stone or Judge Clark, but it'll be, can I finish, Mr. Rivera? That will be assigned randomly. I think they typically try to do it by last name, so it'll probably end up in front of Judge Stone. They'll give you a new court date, and then your motion for, I think this is a Ferretta hearing you asked for today?
No, this is to remove him, to remove Mr.
So it's a Nelson inquiry?
That was it. There was no Ferretta hearing today because you have already, I'm sorry, Papa, that I stepped on you. You have already established that I could defend myself because he was my what is it called? Hybrid counsel.
I'm not talking to you about it anymore, Mr. Rivera. You've told me I'm biased for the last time. I'm going to go ahead.
This is the first time I told you that, Your Honor.
Mr. Rivera, I'm not going to discuss it with you anymore. Your case is going to be reassigned. You'll be given a new court date, and then you can bring that up with your new judge. All right, thank you. You're free to go. You're free to go, Mr. Rivera.
With the information that you requested to the court.
Whatever I requested is moot at this point because you've asked for me to be off of your case. So,
I didn't request you to be off.
well, you said I'm biased or prejudiced against you.
Yes, I did say that you were prejudiced. Yes.
Okay.
What was the day again? July what?
I don't, well, it's going to be the August 25th date for my division as a status date. Once you're assigned to another division, they will give you a new court date.
Okay.
So make sure you keep your address updated with the clerk's office. Thank you, Mr. Rivera. All right, who do we have, Mr. Maddox?
Sorry, Your Honor. This is Mr. Michael Strauss for the court in 24 CF 578 and 25 CF 257. He's indicated to me that he'd like to take the state's offer, Your Honor, so I will write that up.
Does it involve probation?
No, Your Honor. It's 9 months OCJ,
Okay.
concurrent both charges.
All right. I'm just trying to resolve all the cases that might involve probation so we can get probation done today.
Sure thing. All right, I'll write that up for you. We'll bring it back. This is Mr. Robert Watson, Your Honor, before the court in 25 CF 274. Your Honor, I've relayed the state's offer to him. I will write it up. He's indicated he'd like to accept it. It's a credit for time served offer.
When was that offer made?
That offer was made.
This was an amended offer.
Okay. I just would like to get these things rolling so we're ready to go when it's time to be in court. We've been going for 8 hours other than a 15-minute break. So
Yes, Your Honor.
I'm sure everyone wants to get out of here.
I will expedite it and
All right.
do my best to be as fast
But it's
as
time
possible.
served, so again, no probation.
No.
All right. Who else do you have left, Mr. Maddox?
Yep, I gotta write it up.
Firestone? I thought that he was under someone.
It's actually Mr. Maddox's case, Judge.
But I think it's listed on the docket under you.
Yes, sir, I had appeared.
It's fine. I'm just trying to find it on the docket.
Okay.
It's
So
the same thing as before, just.
it's a misdemeanor, not a felony.
Yeah, at least for the DUI.
That's wonderful. So what am I gonna be signing right here? Is this misdemeanor probation?
So there.
But I'm only on felony probation, right?
Oh, okay, I got you.
I'll have to clarify with you.
Also, Mr. Charles Williams, can y'all approach while he's figuring this out?
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Mr. Firestone?
Yes, Your Honor, we have a resolution if I may approach.
Yes, you can.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch, Monday through Thursday from 10 a.m. till 3 p.m.
All right, so it's 2 years probation on the felony possession, and then on the DUI, it's currently charged as a third within 10, but it's pleading to a lesser included of a third outside of 10.
Correct.
What changes on the third outside of 10 other than the mandatory jail time?
There's a few of the license suspension, for instance, changes. That
It
was
says 6 months. Is that accurate on the third outside of 10?
It is. Surprising, but yes.
Can I say something, please?
Yes, Mr.
The
Firestone.
DMV, no matter what, is my license is suspended for 5 years. The court has no, even if you said
For what purpose? Why is it 5 years?
because it was I had two previous DUIs, and on your second DUI it's 5 years. On your third DUI it's 10 years.
Your when was the last DUI conviction?
Last year of October.
All right, so you're going to be a habitual traffic offender probably too.
I hope not so far.
Well, when was your previous DUI?
5 years, yeah.
Yeah, it was within 5 years, but the last one was like on the 5th year.
Well, I'm just saying, if you have 3 certain specified traffic offenses, including DUI, within a 5-year period, you're going to get a habitual traffic offender revocation for 5 years as well.
But that's the DMV though, right?
Yes.
Then I've got no control over that.
Well, I understand. I'm trying to make sure I understand what the concerns are, but just so you understand, for example, if the minimum on a third DUI outside of 10 is more than 6 months suspension, the DMV is going to do that.
Right, yes, sir.
Okay. But I'd like for it to be right. But what was the question about probation? Since it's
Is it both going to be supervised by DOC or?
yes.
Okay.
The only way that we can do it where it's supervised by JCS if it's only a misdemeanor, and that's what y'all ask for. Otherwise, if he's going to be on DOC probation, you don't want to have him done by DOC and JCS because then he has 2 probation officers.
Right, exactly. Yes. Okay.
All right. Can you raise your right hand?
Yes, sir.
All right. Do you swear or affirm that testimony about to give us the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right. State your name and date of birth, please.
My name is Anthony Keith Firestone, December 20th, 1994.
All right. And Mr. Firestone, you're here in 24 CF 2063, charged with possession of a controlled substance, third-degree felony. DUI, third within 10 years, also a third-degree felony. Those are both punished by up to 5 years in state prison. Do you understand that?
I do, yes, sir.
All right. I've been handed a plea and sentencing agreement between you and the state that calls for you to plead as charged with the possession of controlled substance, to do a substance abuse evaluation and recommended treatment, 2 years probation. Court costs would be $515 and waive cost of supervision. It'd also be $150 on the PD fee. Count 2 is you would be pleading to a lesser included offense of misdemeanor DUI, third outside of 10, 6 months driver's license suspended, $2,000 fine, $551.73 in court costs, victim impact panel, multi-offender DUI school, 30-day vehicle impound, 2 years interlock. That's on any vehicle that you drive. You can put your hand down, Mr. Firestone. 50 hours of community service work, 1 year scram device. Is that to be placed before he's released? Okay. 11 months, 29 days probation concurrent, and that's the lesser included is going to be statute 316.193, paragraph 2, subparagraph B, subparagraph 2.
What is a scram device?
The alcohol
Alcohol
monitor.
monitor.
It's like they strap it to your ankle and it detects basically the sweat coming off of your person for alcohol. So if you possess or if you drink any alcohol or handle alcohol-related products, your body will then process that out through your sweat glands, and it detects that. And if there's a positive hit that says that you've been drinking, because you can't do that while you're on probation, then it'll be a violation of your probation.
I have to wear this when I leave jail?
Yes. Have y'all not talked about this, Mr. Maddox?
I just went over the plea agreement with him, Your Honor.
I didn't know what a scram device was. I thought it's something that goes in a car, which I don't have now either.
No, that's the interlock device. So you'd have to wear it, and you wouldn't be released from the jail until they're able to put it on, because it's part of your probation.
I'll wear it. I don't drink.
I understand that, sir. That's what you claim. But you're not going to be released from the jail until a scram monitor is placed on your ankle.
Okay, yes, sir.
All right. Any other questions?
Any other questions?